Item number 18, Lordship. Angus Council is not available.
Item
Adjourn 18, 1A.
18.
Adjourn for today, Lord. Please, sir, 1A.
Item 18 at the request of Mr. Alom,
I, on behalf of A. Alom.
A. Alom. Mentioned on behalf of Mr. A. Alom, matters adjourned for 1 week.
Lordship.
May I please, Your Lordship. For listing pension matters, my lord. On 16, my lord. 16 to
16.
my lord.
All right, 16.
Right.
For admission.
Admission, madam.
Well, I beg to mention for listing. Matter was last posted 12
For admission orders.
admission
Admission 16.
published.
Here for listing, Lordship. Pension matter, Lordship.
Admission
8 yes, Lordship.
16.
Lordship, I beg to mention for my orders. Matter was last posted 6 October 2023. So kindly list the matter on Wednesday, my lordship.
16th February. Change the date. 16th. Yes.
Your Lordship, I beg to mention for listing for admission.
16.
Well, operative portion, my lord, at page 135.
135.
This is in connection with the page number. The order passing the miscase, my lord, connected expedition, operative portion, page number 117. With regards to my lord, grant of OPS, old pension scheme.
117.
117, Roman 10.
Yes.
This court is of the opinion that the person similarly situated to that of the petitioners coming within the category of stipendiary teachers, but who have not yet been able to approach this court on account of various reasons, need not be deprived of the benefit of pension in terms with the rules of 1969, as well as to subscribe to the fund in terms of with the General Provident Fund, Assam Services Rules 1937. This court therefore directs the state respondent authority to grant the benefits of pension in terms with the rules of 1969, as well as to allow such persons to subscribe the fund in terms with the General Provident Fund, Assam Service Rules 1937, after completing the necessary verification in that regard. The same may be done within a period of 6 months from the date of the instant judgment.
Yes. Were you a petitioner here in the IA?
Now, in the IA, thereafter the IA was filed by some of the petitioners, my lord.
No,
For corrections.
This direction for page 117 is passed in your writ petition.
Yes, they are the parties.
Which writ petition number?
WBC number 4353/2022, my lord.
Page number?
It starts from page
15.
14, my lord. It starts
4353.
yes, 4353/2022.
Okay. Heard. Learned counsel for the petitioner. This contempt petition has been filed alleging willful and deliberate disobedience of the directions contained in the judgment and order dated
31/3/2023.
31/3/2023, passed in WPC 4353 of 2022 and other connected writ petitions. It is submitted that in spite of a specific direction, carry out the orders within a period of 6 months from the date of the judgment, and the copy of these orders having been served on the respondents, the respondents have deliberately and willfully failed to carry out the directions accordingly. this contempt petition has been filed. There are late notice issue returnable 4 weeks. Steps on respondent. How many?
3, my lord.
The respondents by registered post AD as well as by you. Matter to be listed after.
Oblige, lordship.
Why? No, this direction is against whom? 1 and 3.
Yes,
1 and 3
my lord, 2 is also, my lord, in between director, my lord,
of
limited edition. It's the nodal.
let us see notices on 1 and 3. 1 and 3 at this stage.
Oblige, lordship.
Yes, who's for health? Get your instructions here.
Lordship.
They've applied for pharmacy college.
No, contempt.
Do you have a copy of the petition?
No, Lordship. अरे नहीं नाम तो कौन है
No need.
All right, none appears. We'll call it up after a while. We'll call it up after a while.
Oblige, Lordship.
May I place the instruction received wrongly?
Will kindly period your lordship order dated 24/1/2024.
Yes, what instructions?
Lordship, instruction received that petitioner received Lordship 11,74,386
What is that?
and the remaining amount Lordship and subsistence allowance in the month of November 22 and January 24 could not be released due to lack of fund Lordship and will release soon Lordship. After receipt of this fund Lordship.
They have released some amount.
Till yesterday night, my lord, nothing was I did not. Till yesterday night, my lord, nothing was received.
So go through this. You have a copy? Go through this.
Yes, my lord, this order has been passed on day before yesterday.
Huh? Whatever it may be.
My
You
lord,
get your
it's a
instruction.
short date, let me have the.
Yes. It is submitted by Mr. A. Chakraborty, the learned government advocate, that subsistence allowance in respect of the petitioner has been released and a report thereof has been furnished by the additional deputy commissioner to the deputy secretary, Government of Assam Revenue and Disaster Management by the communication dated 3/2/2024. It is submitted that subsistence allowance for the months of November, December 2022 and January 2024 could not be released because of lack of funds. However, an amount of 11,74,386 has been released to the petitioner. Stop. There are Mr. J. Patwari, learned counsel for the petitioner, submits that he would like to complete his instructions from the petitioner in this regard. Please, after 1 week. Mr. S. K. Medi for Accountant General, Mr. S. Dotto for Revenue.
So on the other day, my friend was directed to obtain instruction regarding the vacancy position nearby Wapeta.
School education, standing council. School education.
Oh.
Instructions has not been received as submitted by the learned government advocate. Matter be listed after 3 weeks. interim order passed earlier will continue until further orders.
Second.
Yes, what have you got?
Lordship, instruction I have not yet received, Lordship.
Huh?
Not yet received the instruction, Lordship.
My lord, sir, his appointment or advertisement not challenged, he is not partly responded that.
When can you get it?
Lordship, by Friday, Lordship.
Friday. All right, list on Friday. Friday will be 9. 9th.
Fine. Objection.
List on 9th as it is submitted by Mr. D. Upamanyu that instructions have not been received. D. Upamanyu, Learned Council for Higher Education.
Yes, sir.
Mr. M.J. Borua for the petitioner.
Highly obliged.
Regarding non-payment of certain components of the VRS benefit, my lord has directed my learned friend to go over the covered judgment at page 132.
What is the judgment?
It is at page 132, my lord. The authorities were directed to pay the components to the petition. It starts at 132 and the relevant portion is at 146.
Yes.
My lord may be pleased to come to page 147.
Yes.
The benefits that the petitioners will get is called out in paragraph 11, down below, my lord, the last paragraph.
Hmm.
In that view of the matter, it is held that the petitioners are entitled for HRA, MA, and CCA, and the same need to be calculated and included in salary for the purpose of declaring VRS benefits, and accordingly, the respondent irrigation department is directed to consider the case of the petitioner in the aforesaid time, and if HR and so as per clause E of VRS scheme dated 2006 has not been paid, the same be paid within a period of 2 months from the date of receipt of certified copy. But apparently, they are covered.
Hmm.
But one other aspect of the matter, because the petitioners had approached this honorable court at a very belated stage.
No, I have explanation against it, my lord. I was,
Lordship may be pleased to kindly come to page 102 of the petition.
If it is covered, we'll dispose it of. We'll dispose it of then. Hard. Learned councils dispose. Page 146.
okay.
My lord, page 54, my lord. The first NOC was given in the month of June 22 for establishment of a diploma in pharmacy and bachelor in pharmacy. So subsequently, they did not renew it. We came to High Court, my lord. High Court says, my lord, the High Court recorded that there was some deficiency in the infrastructure of the, my lord, institute. So High Court's order is at page, my lord, 94, relevant, my lord. Page 94. My lord, I'll read the last page, my lord. Last paragraph. In view of the above, the authorities in the petitioner to approach the commissioner and secretary to the government of Assam in the medical research department to have a precise information as to what is required to be done and to what extent the dimensions of the laboratories are to be extended, and as extra space is already available, necessary modification be done to the building so that the laboratories of acceptable dimensions are put in place. The authorities in the petitioner may forthwith approach the commissioner and secretary government of Assam in medical research institute, and upon doing the needful may make the necessary modification in the building, and upon completion of the same, to make a representation to the commissioner for an immediate inspection of the space that may be modified, and the commissioner secretary shall do the needful to pass a reason order within a period of so and so. Now they say, my lord, the impugn order says the infrastructure is all right, but there is a moratorium.
There is a,
116
there is a,
moratorium.
why?
Moratorium. It says, my lord, I'll come to that, my lord. My lord, page 116 is the impugn order, and page 117, my lord, second part. Second part, may I just read, my lord, second paragraph. Whereas DME Assam submitted an inspection report dated so and so, and Alama TR College of Pharmacy, Badarpur, Karimganj, wherein DME has opined that Alama TR College of so and so has fulfilled all the required infrastructure facilities to start degree and diploma in pharmacy course as per norms, and government may kindly consider to issue NOC to Alama TR College of so and so to conduct D.Pharm and B.Pharm courses. However, it was also mentioned that the government in Medical Education and Research Department, wide order dated 31/1/21, had imposed a moratorium on the opening of new pharmacy institutes temporarily till at regulatory framework for pharmacy education in the state is notified by the government. But this moratorium, my lord, your lordship will kindly see government of before that, my lord, may I just take your lordship to page 68? 68, my lord. What this moratorium there? This is the USTM college, my lord. This is their, my lord, unit 68. Yes,
Hmm.
68, my lord. This is dated 20 February 23. With reference to the letters on the subject cited above, I am directed to convey NOC to the NEF College of Pharmacies they have given separately. So thereafter also they have given NOC. Malad here, to us, Malad NOC has been given in the year 22, and thereafter they are to continue, Malad. They are, because the institute is already functioning. Now, unless the NOC is given, Malad, they cannot continue, Malad. All the students will suffer besides the institute. So I am just showing one, my lord. They have given NOC to 4 persons, my lord. 4 institute. Similar NOC has been given to 4 institute. I have given it in paragraph, my lord. We have stated
So
in
let them-
paragraph 15 that 4 colleges has been NOC thereafter.
Will issue notice at this stage?
My lord, only
No.
pray, my lord, short date, because my lord, the institute is suffering, my lord, will suffer.
Heard, learned counsel. This petition is filed by the petitioner aggrieved by the order. You are aggrieved by the 1711.
My
1711 by the
And my lord, your lordship may record that a similarly situated institute has been given NOC on 22/23. 4 colleges have been given.
respondent number 3, whereby the petitioner who has established the College of Pharmacy had applied for NOC, and the NOC was rejected by the state order on the ground that the appropriate department in the government has issued a moratorium on the opening of new pharmacy institutes temporarily till a new regulatory framework of pharmacy education in the state is notified by the government. So, learned counsel, senior counsel for the petitioner further submits that while on one hand, the NOC was rejected by the impugned order by the department, on the other hand, other similarly situated institutes have been given the NOC, notwithstanding their being a moratorium issued by the government as stated. So under such circumstances, the petitioner is before this court praying for appropriate direction or order. Mr. Bora. Does it come?
I am for respond number 1, 2, 3, and 4, my lords.
Appears for respondents 1, 2, 3, 4. Who's for 5?
5, my lord, notice
Not
has
that
to go.
relevant, my lord, because they have already given whatever is necessary.
No, that is relevant, my lord, because my lord, as per the
Uncertain.
new regulatory, my lord, Srimanta Shankardev University of Health Sciences has
You're not representing
No, my lord.
any standing council, or is there any standing council?
No, my lord. Notice.
All right. Who's for higher education?
Higher education.
Mr. D. Upamendu appears for higher education. Notices on
Council of
respondent 5
India.
and 6 by usual course and registered post AD.
Higher education, my lord, D. Upamendu may represent, my lord.
Now we recorded his name.
Yes, sir.
Let the matter be listed after the returnable date. Respondents may complete their instructions and file necessary affidavit in the meantime. Further orders, if required, will be considered upon the next returnable date.
And may I pray, my lord, it will be taken after 2 weeks.
2 weeks.
And initially they were given NOC. Only this continuation of the NOC. This is not done, my lord.
All right. Make it returnable on 28th of February. 28th February
For
Public.
further necessary.
for further orders. If you
No, earlier pharmacy council was represented by CGS.
You can find out if CGC appears, then no difficulty. You can serve copies if the CGC appears.
In this case, instruction, my lord, notice may go, my lord.
Huh?
The earlier, my lord, earlier one.
Earlier,
Senior pen, senior advocate, that case, my lord.
we had issued notice.
Yes, my lord.
Yes, we had issued notice. Yes.
Petitioner had served as a research assistant in
Your
tumor
benefits,
history.
your benefits have not been released.
My,
Your benefits have not been released.
not released. And since 1991, she is working in a sanction and as per address, she got the appointment. So earlier she has approached this Honorable High Court.
Yes, Mr. Bora, what seems to be the problem?
My lord, now only I have come to know about this matter because our names were not shown, my lord. I have come to know, my lord.
Lordship, kindly see page 74. It is clarified by the principal cum chief superintendent Assam Medical College, Dibrugarh. Kindly see page 74.
Yes.
With reference to, I have to honor to furnish here with the required information and document in respect of Dr. Rafika Akhtar, Research Retired Hospital Tumor Registry, AMCS, Dibrugarh for favor of your perusal and kindness. In 1991, Hospital Tumor Registry, Assam Medical College, Dibrugarh was functioning under ICMR, National Cancer Registry Program. The post research was originally appointed as per requirement of registry by observing guideline and procedure of ICMR. For the post existing working staff registry created by Assam government under non-plan including RO 2010. One notification was issued on 2/3/2011. The government of Assam allowed to draw a salary through Treasury of Dibrugarh from 1/4/2010 to 28/2/2011 pending salary under non-plan. Also mentioned RO has been rendering service in with effect for 99 including research officer in 2010. The post of researcher was appointed initially by instruction of ICMR as per the rule of ICMR 1991. So a question about whether it was against vacant section post does not arise. In later period time, it was created by government of along with other posts of registry in the interest of functional cancer research in registry. The post under the Project Hospital Tumor Registry AMCS was held by the Dr. Rafika Akhtar Vice Government Letter so and so dated 11 January 2010, when the pay scale in respect of his post were fixed pay and as per order pay scale research 7,251 to 11,825. Regarding regulation of this, we have submitted proposal to your good office by this officer so and so dated 27/2011 and 14/2/2013. As per instruction, as per statement, the period from the salary has not been receiving by Dr. Rafika Akhtar from March 2013 to July 2016. During submission of salary with Dr. Rafika for the month of 2013 at Treasury Officer Dibrugarh, the Treasury Officer has raised objection verbal that deduction of GIS at ₹400 in respect of Dr. Rafika could not be deducted since Dr. Akhtar does not possess the pay slip in spite of her pay and allowance fall under the payment for, and such her salary with effect from 2013 to 2006 could not be submitted to the. That's in the earlier represent.
Let him obtain instructions here.
Yes.
You get your instructions. Learned Council, Mr. DP Bora, Learned Standing Council, help will obtain the required instructions in the matter. At this stage, the court does not consider it necessary to issue notice. However, extra copies of the writ petition be furnished
Yes.
to the Standing Council within 1 week from today,
Yes, ma'am. To read 3 days. 3 days.
within this week,
Fine.
within this week. Matter be listed again on 21st. Can you get it on 21st February? List on 21st.
My lord, our name may be shown in the court.
Names of all standing councils be reflected in the course list.
My lord, standing council help because in the court it is shown as
Standing
SC.
Council Health,
Yes.
Mr. S.K. Mehdi appears for Accountant General.
Obligation.
Yes.
Result, the matter pertains to non-payment of provisional family pension and provisional gratuity money. The husband of the petitioner serving as assistant teacher and school was provincialized in the year with effect from 1/1/2013 and falls under the new pension malad. And subsequently, in the year 2016, that the government of Assam filed unlisted case 23 and office memorandum stating that the entitlement of the provisional family pension. But in spite of that, the provisional has not been granted to the petitioner.
What is the order at page 44?
Page 44, my lord. In similar circumstances, this honorable
Similar.
court passed, order, my lord. Directed the respondent to, finalize the same in terms of the office memorandum. Page 45, my lord.
Which office memorandum you are referring?
Kindly see, page number, 23, my lord. 14 June 2016. Page 23, my lord.
Yes.
And last, therefore, government of the East pleased to extend the following additional benefits to the state government servant coming within the purview of NPS, appointed on or after on getting discharged on invalidation, disability, or to the families of such employees covered by the NPS as have died in harness since 1/2/2005, with a view to mitigating the hardship meted out up to them and to their families in the line of government of India on provisional basis only until further orders when the rules regulating this venue under the NPS are sent and enforceable. As per that notification, the petitioner is entitled.
What do you say, Mr. Corpusary?
My lord, this office memorandum at page 23, which lordship is parodic. My lord, this doesn't deal with, my lord, provisional pension. My lord, under the scheme, my lord, of the new contributory defined pension scheme, my lord, the concept of provisional pension is not, my lord, called out as such. Because the scheme is such, my lord, that there has to be a contribution from the employer as well as the employee. And the fund is, my lord, that is, my lord, put in, my lord, graded mutual funds and other, my lord, annuity giving, my lord, income giving, my lord, funds. Those are applied. And my lord, once the employee dies, my lord, then, my lord, he has two choices. For a particular period, my lord, a fixed amount of money, my lord, will be, my lord, credited to the legal heirs of the employee, my lord. in the form of, my lord, annuity benefits. And thereafter, my lord, if he chooses, my lord, the legal heir chooses, my lord, then, my lord, the entire sum of money, my lord, is credited. This is the scheme, my lord. This office memorandum, lordship may kindly be pleased to come to page 24. This is the, my lord, part of that office memorandum. Lordship may be pleased to come to clause 7. My lord, I am reading it, my lord. The
Yes.
above provisional payments are subject to adjustment against payments to be made as per rules framed on recommendations of the high-level task force and adopted by state government. So this will be the additional payment. This office memorandum only speaks of additional payment. Over and above, my lord, the legal heirs or the employee concerned is, my lord, entitled to new pension, my lord. Then, my lord, clause 9. This is important here, my lord. Clause 9 at page 24, my lord. In case where owing to discharge on invalidation date of the employees, the amount of accumulated fund in NPS account is paid to the employee family of the employee. The total of monthly annuitized pension from the date of death or discharge till the date he would have retired, had it continued in service, needs to be worked out as per guidelines of PFR ADA, and the same shall be deducted from the total benefits under notified rules governing additional benefits are in place. So at this stage, lordship may be pleased to issue notice, my lord, because the fact as to, my lord, what exercise has been carried out, my lord, more particularly by the administrative department concerned towards, my lord, releasing of the money, my lord, to the petitioner, because the petitioner is the wife, my lord, of the deceased employee. And a similar order is there, my lord, but if lordship disposes of this application, my lord, in terms of the similar orders, my lord, perhaps petitioner may not get any benefit, my lord. It will.
Okay, heard, learned counsel for party issue notice, return of information. Our board pujari is notice on behalf of finance,
My lord, I am appearing for respondent 3, 5, and 10.
3, 5 and 10. Mr. P.N. Sharma for respondents 1 and 2. 1 and 4. 1 and 4. Mr. Musari for 6.
6,
7, 8,
10, 9.
9. 6, 7. Mr. P. Soikia for 2. Since all the respondents are represented by the standing council, notices are waived, but extra copies be furnished within the course of this week. Matter be listed after the returnable date. Respondents, more particularly education,
BTC money.
BTC,
Yeah,
BTC and
BTC, my lord.
finance. Will obtain their instructions and apprise the court as to the claims made by the petitioner. List accordingly.
Oblige.
Problem.
This is okay. My lord, this matter may kindly taken up next week, my lord.
2012.
Yes, my lord. In fact, my lord, some other connected matter has already been discussed for me. Some other connected matter, my lord.
Yeah, what is that order?
That has, yes, my lord, I have got this order, my lord. In that light of that, my lord, two petitions were there, my lord. There has been discussed. Yes, okay. Yes. Similar, my lord. Similar, exactly. Other same list.
Yes, please read.
To read this, dear my lord, out of the same regulation order, my lord, some, there are three requisitions I have filed, my lord. Two of them had already been disposed of. And this was left.
Yes, what do you say?
Lordship, let me verify lordship here, otherwise we have filed our affidavit lordship in this matter. Lordship may kindly peruse page number 61. Here it says the petitioners appeared before the screening committee. Their initial appointments were illegal. And subsequently they were made to appear before the screening committee. Some of them appeared in the screening committee and some of them perhaps did not appear because the record is not available in the screening committee. And page number 12, lordship, sorry, 66, paragraph 12. The name of the petitioners in the present writ petition, except petitioner number so and so, so and so, so and so, were found in the screening committee under Kachar district. But they have not- Paragraph 12,
12.
lordship, page number 66.
Ah.
Pursuant to that screening committee process, lordship.
Hmm.
That the ancient upon humbly begs to state that the name of the petitioners in the present writ petition, except petition number so and so, so and so, so and so, were found in the screening committee
But they
report
did not fulfill.
under Kachar district.
So these petitioners'
But they
names
have
were
not-
not found.
They have not fulfilled the criteria for receiving salary. Those criteria were there. So they did not fulfill that criteria, hence their,
No. What happens to petitioner 10, 12, 13, 17? Their names were available or not available?
their names were available in the screening committee report. But because they did not fulfill the criteria of receiving salary up to 2007, in terms of the cabinet memorandum,
No, kindly read your paragraph.
lordship,
Your paragraph says names of the petitioners, except petitioners 10, 12, so and so, so and so.
were
found
found,
in the screening committee. Means the names of the petitioners,
lordship, were found. Except these petitioners,
except these,
rest were found,
rest were found, but
Found.
they did not fulfill.
but they did not fulfill the criteria.
And so far as these petitioners,
Yes, these petitioners, next paragraph, further in respect of the petitioner number so and so, so and so, these petitioners, no record were found in the screening committee list because there is no record of their appearing before the screening committee. As such, their cases could not be considered for accommodation.
then what remains?
My lord, except this petitioner, there are 80 petitioners, my lord.
Huh?
There are 80 petitioners, my lord.
No, it is stated in para 12.
Yes, my lord, they said accept this, my lord. If they are not found, that is separate thing, my lord. What I am not for recommendation or recommendation, I am for area salary, my lord. I had what my salary should be given. That is
Yeah.
why, my lord. And
So
this one of the,
The department has filed an affidavit saying that those petitioners name the petitioner numbers who are mentioned in para 12,
my lord, I have seen that,
except those,
my lord.
others' names were found,
Yes.
but they did not fulfill criteria.
Right.
These petitioners, there was no record.
No record.
So therefore, in totality, all the petitioners,
Hmm.
either their records were not found
My lord.
or they did not fulfill the criteria.
Right.
So therefore, how,
My lord, I had worked, my lord, that
What
salary, my
claim?
lord. Yes, I had worked there, my lord. Now I am for salary, my lord.
No,
And that is why, my lord, coordinate branch of this court, my lord, had directed to examine the case, my lord. Not.
no, what is the point of examination of a case having been filed in 2012?
Yes, my lord. There are subsequent.
The whole purpose of coming to court is
No, my lord.
for examination of your case.
No, my lord. What happened, my lord, subsequently, there are connected, a series of cases were there, my lord. Bunch of cases were there, my lord. That some on the basis of my case repetition, my lord, subsequent all the repetitions were dismissed. Subsequently, DW was filed and all those repetitions are again restored, my lord. And I have annexed some cases of in another order, my lord. I have annexed with my affidavit, my lord. Now, my lord,
No, what orders are you asking for?
let them examine.
Why will they examine? Why should we direct? You go and approach them. If they want to examine, they'll examine. Why should there be a direction to examine?
That is why my lord, coordinate bench, my lord.
Coordinate bench may have issued, we'll examine this matter.
Yes,
We are
my lord.
not bound
For the-
unless the case, the facts and circumstances are exactly similar.
Yes, yes. Exactly similar. Out of the same leak.
Was
my
an
lord.
affidavit like that filed in that, those cases?
My lord, out of the same regulation order, my lord, 28, 2005.
In your reply affidavit, you did not respond to para 12.
My lord, I have in reply with you, my lord.
There is no response to
No.
para 12.
There is no reply. No,
There is no response.
no response in regard to paragraph 12.
There is a specific finding. Now, in view of para 12, what directions can we issue?
My lord, at paragraph 7, I have issued that whose services regularized as per decision of the cabinet meeting dated 24/2/2005 and subsequently on the recommendation of the Monon Committee. And as such, further regulation is not necessary. My lord, their service already had been regularized, my lord. Their regulation order, my lord, that has never revoked. my
What
lord.
is the criteria, Mr. Sharma? What is the criteria stated?
Criteria was there,
At the relevant time-
they have to receive salary up to 2007, March 2007. Number one, to be accommodated as tutor. And those who have received salary up to 2007 and obtain their that BT training, basic training within 2011, they will be accommodated as tutor. Here, Lordship will find this criteria, Lordship.
When were the petitioners regularized?
My lord, page 37, my lord. 28, 2005, my lord.
No, in so far as the respondents are concerned, do you dispute their
Lordship.
do you dispute their contentions that they were regularized?
Lordship, that we dispute because their initial appointment itself was illegal, Lordship.
My lord,
As a
that-
result, in terms of the cabinet decision, Lordship, cabinet memorandum, Lordship, the screening committee was constituted and applications were invited. We have given a detailed affidavit. Your Lordship will find the affidavit, this detail in paragraph 5 onward, Lordship. Paragraph 5 onward, page 62. May I read, Lordship?
Yes.
The deponent at this stage, instead of controverting the statements and averments of the petitioner made in the writ petition paragraph, was deemed it fit to file this affidavit in opposition to apprise this honorable court the stand of the department as to why the petitioners have not been paid salary. In order to explain the stand of the department, the answering department at the very outset would like to give a brief background of the constitution of the screening committee by the government for identification of irregular teachers in LP and UP schools in the following paragraphs. Paragraph 6. That the answering deponent humbly begs to state that in compliance to the order dated 2/3/2010 passed by this honorable court in 1048/2004, the education department placed the matter of regularization of the irregular teachers before the cabinet in its meeting held on 16/2/2011. Thereafter, education department proposed to constitute a screening committee to examine the validity of the appointments of these teachers. Accordingly, by OM dated 15/11/2011, a screening committee was constituted to examine the cases of irregularly appointed teachers so as to take a decision for their regularization and entitlement of salary or otherwise, with a view to examine the selection procedure, the nature of appointment, status of posts, working status of salaries, academic qualifications, etc. The Director of Elementary Education, Assam, invited application from these illegally appointed teachers during 1991, appointed during 1991 to 2001 throughout the state by an advertisement dated 1/2/2012 and 4/2/2012 in local newspapers. Paragraph 7, that in response to the said advertisements for screening applications were received from irregularly and illegally appointed teachers, which includes those petitioners also. Teachers throughout the state, after conducting preliminary examination at the director level, the Elementary Education Department by notification dated 4/6/2001, 2021. Sorry, the date is, there is a mistake, Lordship, I will clarify. Constituted 5 screening committee headed by the divisional commissioner concerned and principal secretary of the 6th schedule area and BTC to examine these applications and the report of the preliminary committee. The said 5 screening committee were Upper Assam Division, Lower Assam Division, North Assam Division, Hills and Barak Valley Division and BTC area. Paragraph 8, that thereafter the divisional screening committee verified all the applications and submitted their reports with recommendation of views to the government for further action. However, due to complaints from various corners, the government directed to for re-verification in respect of some of the districts. The respective screening committee, after causing re-verification, submitted their reports to the government. After verification of the reports of the divisional screening committee, the following categories of teachers are identified. There are 4 categories of teachers. Category 1, recommended and working till date, 136. Recommended
Now,
but discontinued.
petitioners fall under which category?
They fall under, here they fall under this category 3. Not recommended but working till date.
They fall under category 3.
3. Because this, in regard to this 8470 teachers lordship, this screening committee were constituted lordship. Because this recommended and working, they have been regularized. Recommended.
Now from these 8470,
Lordship, now from
after
this
screening, there were 3 lists.
Lordship, the state respondent had decided to issue individual so-called notices to the 8470 candidates.
No. First tell us,
Lordship.
this inquiry was conducted in respect of category 3.
3.
Pertaining to 8470 teachers.
Lordship.
Now, what was the result of the inquiry?
Lordship, after verification, Lordship may kindly peruse paragraph 10.
Yes.
That, however, in the meantime, a discussion was held between the Honorable Minister of Education and the Teachers Association of illegal teachers. As per decision of the meeting and as per the suggestions of the Honorable Education Minister, the department had proposed to take a decision to solve the problem of these irregularly and illegally appointed teachers subject to approval of the cabinet. Accordingly, the departmental committee was formed by the government in the Elementary Education Department to verify the salary status and qualification of this category 3, irregular appointees. The committee prepared 3 lists based on the screening committee report. These 3 lists are, Lordship. Number 1, the teachers who have received salary up to 2007 and onwards and having JBT, DLED degree, junior basic training and DLED are included in list 1, who were ultimately accommodated as teacher. List 2, the teachers who have received salary up to 2007 and onwards and not having junior basic training, BT or DLED are included in list 2. And list 3 was who have neither received salary nor having prescribed training. These are the list 3. So that after the series of discussion, 11 numbers, Lordship, that after the series of discussion and views of the various
under
departments.
which list they fall?
They now in this they fall under list 3. Because except those, some of the teachers.
No, what except? You have to be specific which falls under list 3.
List 3, they have neither received salary,
No, this is
having
in-
prescribed
this is-
training.
No, this is in respect of
In respect of Lordship,
petitioners whose
petitioners,
name, whose
except 10, 12, 13, 17, 18, 19, these.
So, except these petitioners,
Lordship.
the other petitioners fall under list 3.
3.
But there is no clear statement to that effect.
Here it is that, Lordship, but they have not fulfilled the criteria of receiving salary up to 2007 and onwards and having. So those who have not received salary up to 2007 and they do not having the junior basic training, they fall under list 3.
Now, these records could not be found in respect of the other batch of writ petitioners means? Why were the records not found?
Lordship, perhaps they did not appear before the screening committee. Because the entire, the record is not found in regard to these teachers. How many teachers? One, two,
What
three, four.
directions are necessary now? What directions can we issue? It's a
My
very
lord, kindly see
detailed affidavit.
unexpected matter, my lord, kindly see, my lord, that regularization order, my lord.
Hmm?
Regularization order, my lord, in part of which, my lord, petition has been working, my lord.
No, no, if you are aggrieved, then you have to challenge this. What is this? Verification. The verification report you have
My
to
lord,
challenge.
I may go, I may challenge, that is separate thing, my lord. What I am
Ah.
submitting, my lord, that regularization order, my lord, dated 28/2005, my lord. That order, my lord, they had never mentioned, my lord, in part of which, my
Mr.
lord,
Counsel,
my lord,
whatever you say in response to this, there is an affidavit filed.
my lord.
In the affidavit says that in respect of certain petitioners, you do not fulfill the criteria, meaning thereby that you have not received your salary up to 2007. And the rest, there are no records.
My lord, what happened, my lord, in this case, my lord, they were appointed in the 94, my lord. 94, my lord. Now they are saying that as far as the new education policy, my lord, 2010 Act, Right to Education Act, those are they are being imposed.
So
my lord.
therefore, that
17
report
years,
has to be challenged if you want.
my lord.
These submissions which you are making,
My lord.
that this report does not take into consideration the conditions which existed while you were appointed in service. We cannot go into the report unless the report is here and you make a specific challenge. In so far as this writ petition is concerned,
Right.
in view of this affidavit,
Right.
we need to close it. How can there be a direction to again re-verify? They have verified. They have verified, they have given a report. If you are aggrieved by the report, you have remedies.
Actually, my prayer was for not regularization, my lord, for salary.
Whatever it may
My
be.
lord. And they are saying that cannot be recommended, my lord. They are saying like that. My lord.
They are
But
saying that one
whatever-
batch of
what
writ
I have-
petitioners, listen, they're saying one batch of writ petitioners do not fulfill the criteria. Why? The reasons are not given. The other batch, no records are available.
Right.
Now, insofar as your writ petitioners are concerned, you'll have to get hold of that report. What specific directions can we give here? Can we say that notwithstanding the writ petitioners not fulfilling the criteria or the records not being there, your cases will again have to be re-examined for payment of salary? The findings in the report, some finding is necessary that the report is correct or not correct or partially correct. Yes? We'll close it, we'll give you liberty to challenge the report if you want. No liberty is necessary, but we'll mention it.
My lord, can you next week, my lord?
Not next week.
My lord, I will have to discuss with the
There is nothing to discuss. We are going by
My
your
lord,
pleadings.
what
We are
about-
going by your pleadings on record.
Yes, my lord, the coordinate benches have already order.
We do not
order,
know,
my
but
lord.
coordinate benches does not reflect the affidavit. Perhaps in those matters, the affidavit was not there.
No, my lord, the entire matter was in the series, my lord. Subsequently, they were segregated, my lord. All were series, my lord.
Series?
Total 16 petitions are there, my lord, earlier.
These are individual orders.
Now they are passing individual order.
Uh,
That is why, my lord.
Might not have been the
Kindly,
identical
next week,
matter,
my
that
lord,
is why it has been
we
segregated.
just want to make a part hit or part hurt also. No problem.
Not part-heard. We don't want part-heard. This is because of 2012 matter. We are going by your pleadings.
Fine.
There is an inquiry done. Your petitioners are found to be not eligible. Your option is to challenge that inquiry report. Instead of that, you want the department to, a direction to the department to consider your claims for payment of arrear salary. They say that you are not eligible.
My lord, fact is that I had served, my lord. Now, my lord, if they are not paying my salary, my lord, That will be, my lord, forced labor, my lord.
They are saying that you are not eligible.
At that time, they had regularized on basis of my inquiry report, on the basis of qualification, they are regularized, my lord.
You
And
have
the
filed a reply,
regularization
you have not.
was passed by the director.
Have you seen the affidavit?
Well, I have seen, my lord.
Have you seen your reply to that affidavit? You have not stated anything.
My lord, next week, I'll.
Not next week. We will post it on Thursday.
My
The
lord,
request of Thursday.
next week will be better, my lord.
No, not
my lord,
better.
Because they have to come from Kasar, my lord.
No,
And-
no, 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 no. We are not here to do that. We are dismissing. If you are aggrieved, you go and appeal. Then we'll dismiss it today. We are giving you time to reflect on this if you want. That's
Yeah.
all.
Definitely, I have to answer their
We don't know. We are keeping it on
next
Uh,
Monday, my lord.
8th. We are giving you one opportunity if you want. 8th. 8th of February.
9th, my lord. At
No,
least all-
8th. We'll have to dispose it of. 2012 matter. Your pleadings are clear. Affidavit is clear. You have filed your reply.
I filed the additional reply, my lord.
You filed your reply. What more do you want? You are flogging a dead horse.
Of course,
It's not going to come to life.
I'll try my.
You want to keep flogging a dead horse. All right.
My lord.
Thursday, 8th.
My lord.
For further hearing.
May I please your lordship, the matter become infactual.
Mr. Your name,
B. Kumar, on behalf
Mr.
of,
B. Kumar,
on behalf of Mr. U.
counsel appearing on behalf of Mr. U. Doctor submits that the writ petition has become infractuous and therefore the writ petitioner does not wish to press the writ petition any further. Accordingly, writ petition stands dismissed as infractuous. Mr. D. Upamanu appears for the respondents. Interim orders, if any, stands vacated. Pending IAs are also dismissed.
Highly obliged.
Regarding this matter, I have already submitted a order, madam. That same type of petition has already been dismissed, madam.
Lordship, I have perused the order. In that case, your lordship may close it because the issues are similar. The prayers were also similar. They have, in this matter also, they were praying for,
Give us
benefits
a
of
copy
elders.
of the order again. What is the number of the case?
My lord, 4450, 2016.
Shakir Alam.
Shakir.
You want to say this is covered?
This is covered.
Because the prayers are similar, your
All right. Heard learned counsel for the petitioners. It is submitted at the bar that the issues raised in the writ petitions stand squarely covered by a judgment and order dated so and so. 19/5 to 2023, passed in WPC 4450 of 2016. Accordingly, the writ petition stands disposed of in terms of this orders. This is item number 12 and 13.
12. So, what's similar?
All right. Writ petitions disposed of.
Objection.
Diploma.
Please, your lordship. So in this matter, we have lost our contact with the client. Lordship, perhaps they have got their relief, lordship, as earlier order, lordship.
It is submitted by Mr. Counsel for the petitioner that the writ petitioners do not wish to press the petition any further. Accordingly, same dismissed as not pressed. Interim orders, if any, stands vacated.
Lordship, we will allow liberty. If I'm not sure, lordship, they have got their relief as per instruction of the learned council of the.
Then you have to withdraw it.
Lordship, yes.
Does not wish to press the writ petition any further. Liberty is granted to withdraw the writ petition and file afresh if the remand subsists. Writ petition accordingly dismissed on withdrawal with liberty. In
Obliged.
order, if any, stands vacated. Anyone for the respondents? Mr. Who's appearing for Standing Council Secondary Education? Secondary. Yes. Yes.
No, I was supposed to file an affidavit, my lord. But the issue dates back to 2003. Some records are missing, my lord. It's some more time to test out the record, man.
Yes.
2019 metal lot.
What is the grievance here?
Of 2003, my lord.
Evans is to provide the petitioner's salary at ROP prescribed rate. At per.
This is the letter, my lord, some records are missing, my lord.
We'll give him
Take out the
some
record
time.
of 20 years back, my lord.
Mr. S. Bora, Learned Counsel appearing for SSA.
SSA, lord.
Prays for further time as is unable to complete his instructions in the matter. As it is submitted that the department is in the process of tracing out the records connected to the case. Mr. Chaudhary.
Yes, sir.
Learned Counsel for the petitioner does not object to the prayer made after 3 weeks.
Lordship.
3 weeks.
May I pay for a fixed?
You keep
Lordship,
it-
my lord.
you take it back. 3
Of lord.
weeks. It will be in March. First of March.
Obliged, Lordship.
But before my learned senior begins, in this matter, my lord, earlier Mr. Banerjee was appearing for the bank, my lord, so he has since passed away. But we have received the brief on Saturday. I pray for some time to go through the pleadings, my lord, and then your lordships may.
Mr. Chaudhary.
The pension matter, my lord, no difficulty, my lord. I'm not seeking for much time, but after a week or so, it may be taken up. My lord.
It is submitted by Mr. D. Ganguly that he has been recently engaged in the matter. He prays for some further time. A. Ganguly, further time to obtain the required instructions in the matter. Mr. D. Chaudhary, Learned Counsel appearing for the petitioner, submits that this being a pension matter to be listed after 2 weeks. 2 weeks is good enough.
Gotcha.
Let date will be listed again on 4th of March.
Previous lordship, my lord.
Yes.
The pension of the petitioner have been not released, my lord. No provisional pension has been filed, my lord, after filing this petition, my lord. I think, my lord, they could not finalize the pension because of the not having the records, my lord. These records pertaining to my lord, the petitioner along with others has been seized by CBI, my lord. They have said to been reconstructed, my lord, my pension papers, my lord, taken from the copy of the my lord court. They are supposed to release only, my lord, they have in the affidavit said that the dispute of death, my lord. I am not disputing, my lord. When I have retired, my lord. Even, my lord, if they count my date of birth is different, my lord, the 6 months I have stayed more, my lord, than my retirement age. That they also cannot recover, my lord, that part. 6 months, my lord.
Yes.
Look, my lord, this anomalies, my lord. The original copy was submitted to the CBI court. And from the CBI court, they have received the true copy. In true copy, date of birth is 1/1/1960. But in duplicate book, service book, my lord, they only mention the 1960 year of the birth.
Without
date
that.
of birth is not there.
Not there.
That's why the anomaly is there. And provisional pension has already been released. And now finalized the lordship may dispose it, my lord, on taking the 1/1/1960 the date of birth. His pension can be, my lord, prepared for final release of the pension.
On what basis are you submitting?
But lordship, kindly see our affidavit, paragraph 5.
5.
Yes. Respond number 5. This is, my lord, used to find an police.
Yes.
Yes, respond number 4. Lordship, paragraph 5, last portion, my lord, last, can you see? Accordingly, this office received true copies of the service sheet. And as per true copies of the service sheet, his date of birth is 1/1/1960. As per the true copies of the service sheet, he had to retire on 31st December 2019. But as per duplicate Malot's service book, he's there, that was mentioned in the February 1960. That was he's retired in June 2020. He
He
stayed
overstayed for 6 months.
6 months, Malot. That is the case, Malot. So taking into the Malot, the true copy. True copy is the
Do you dispute this statement?
My lord, I'm not disputing, my lord.
Okay.
If my lord record says so, my lord, I don't have now any documents, my lord.
So there will be some recovery.
That cannot be, my lord, in case of get 3 4 employee, my lord. There is a circular of the government of Assam,
Is it?
which is, my lord, wrongly paid,
Let us see.
my lord.
and he was asked to also Malot to submit any further documents to Malot to substantiate his date of birth. Malot, he did not submit anything.
Paragraph 4.
What is the recovery amount?
My lord, they have not claimed that we are to recover, got to be recovered, my lord.
Okay. Very well, then,
No need, also, my lord.
all right.
They have not saying that they will recover, only that of my lord, part is dispute.
Okay, heard learned counsel for the parties. This petition is filed by the petitioner. It's the limited prayer for sanction of his pension, leave encashment, retirement gratuity, and other services. An interim prayer was also made for release of provisional pension. The writ petitioner was serving as a member of the armed branch of constable, having been appointed in the year 1984 under the 9th Assam Police Battalion headquarters stationed at Bahrampur, Nagaon. Subsequently, he was promoted to the post of Havildar, posted as PSO under the control of the Superintendent of Police SP within bracket E in Assam, Kahilipara. As the petitioner was approaching superannuation, he was served with a communication dated 26/11/2019 by the competent authority indicating his date of superannuation. Stop. The name of the petitioner appeared in the said communication for the month, at serial number 19, showing his date of superannuation in the month of June 2020. Showing his date of superannuation to be 30 June 2020. That is 3006 2020. Stop. Subsequently, the petitioner superannuated on 3006 2020. Stop. However, his retirement benefits have not been released, although he was entitled to such benefits immediately upon his retirement. Upon making necessary inquiries as to why his pension and other service benefits have not been released, the petitioner was required to submit particulars and declaration papers, etc. Stop. Petitioner was informed that his relevant particulars and declaration papers were not submitted. Stop. It is apparent. The learned counsel for the petitioner submits that there is no adverse remark nor any pending disciplinary action against the department. Stop. It is submitted that prior to superannuation, government servant is required to be informed of the necessary documents or papers which are required to be submitted before the competent authority for grant of pension. Stop. However, in spite of requests made, these documents or papers were never furnished the petitioner. Stop. The petitioner has submitted for 36 years as constable in the armed branch of the Assam Police Battalion, and there is no cloud on his entitlement for pension or other retirement benefits under the rules of the Assam Services Pension Rules 1969. Stop. For no fault of him, his claim of pension cannot be taken away. Stop. Under such circumstances, petitioner is before this court, filing the writ petition. There. The respondents have filed an affidavit. The respondent number 4 has filed an affidavit, wherein at para 5 there is an averment that pursuant to verification of the papers and requisitioning of the relevant documents from various sections, the true copies of the service sheet have been received. And as per his service sheet, his date of birth is shown as 1st of January 1960. And therefore, he ought to have retired on 31st of December 2019. Stop. 2019 instead of 3006 2020. This discrepancy appeared as at the relevant point in time, the date of birth which was relied upon was the date of birth reflected in his PAN card, which was shown as 2/2/1960. Because of these discrepancies, the regular pension could not be released and only provisional pension was granted. Stop. Better. Learned counsel for the parties have been heard, pleadings on record have been produced. By office memorandum number so and so dated 14 June 2019. The Finance Department, Government of Assam has issued memorandum in respect of recovery of wrongful / excess payments paid to the government servants. Stop. This office memorandum.
Since my lord, there is no whisper about, no notice was issued for recovery of the, my lord, his overstay. My lord, this notification is not given effect to my lord. Because they are not saying anything about this, my lord.
Then
Recovery.
why have you not released?
Released only these anomalies. 1/1/1960, I in PAN card, my lord, that is 2/2/2060. The anomaly is there, it should be clear by him, my lord. By, after receipt of the true copies, my lord, they have come to the my lord, final knowledge of the authority that his date of birth is 1/1/1960. So according to
Maybe
his
while
date-
finalizing, my lord, they may try to.
the different
recover
thing,
the-
like different issue, my lord. Recovery is the different issue, but like here issue was the only anomalies is there, my lord. That's it. After, my lord, they have come to know this notification not necessary, my lord.
From the affidavit, from the averments made in the affidavit, we seen that the date of birth has now been finalized.
তুমি এৰি দিলি হ'ল আৰু পেঞ্চনটো এৰি দিলি হ'ল
That his correct date of birth has come to the knowledge of the department from the from the two copies of the service sheet received, wherein it is reflected his date of birth is 1st of January 1960. The department will now proceed to release his pension, regular pension, in terms of the provisions of the Assam Services Pension Rules 1969, without any further delay. After the adjustment of the amount released as provisional pension. Stop. Department will release the pensionary benefits and other pensionary and other retirement benefits to the petitioner within a period of 60 days from the date of receipt of certified copy of this order. The petition accordingly stands disposed of.
Hello.
Mr. Borpujari appears.
My lord, I appear for respondent to my lord, finance department.
Mr. Borpujari for finance department.
I'm for 1, 3, and 4.
This is a very peculiar case.
Peculiar case.
Not because of the facts, but you see, regularly we don't find any affidavits being filed. Here there are 2 affidavits filed by the same person, saying the same thing.
I think, my lord, at a council, different council, I think they have forgotten. The one received instruction, other is also received instruction. I think.
Second one is elaborative, my lord.
Huh?
That is happened sometimes, my lord.
It happens. One was filed on 12th of January 2021 and the other was filed on 4th of May 2023. saying the same thing.
So, right.
Writ petition accordingly stands.
Obligation.
It way. Overpay, excess pay. Yes.
The petitioner has not been given the pension, my lord. Already, my lord, the inspector of the Karbi Anglong District Council wrote letter to the, my lord, director of pension, my lord. But they have already, my lord,
Yes,
supplied all everything, my lord. But director has not, my lord, released that.
some affidavit was to be filed.
No, my lord, already, only letter was, my lord, 6/7/23, my lord. But several time, my lord, they have taken, my lord, instruction, time, my lord, for time and.
Yes, madam, what do you say?
Lordship, government took time for instruction, Lordship, regarding our application for relaxation.
Who's taking time?
Government, my lord. Last one, your lordship order 19/12/23.
And my lord, as per our instruction, my lord, the inspector of schools, my lord, of the Karbi Anglong district, he is requested to place the pension proposal and regarding the approval in the Department of, my lord, Administrative Reform, my lord.
Why?
My lord, because Administrative Reform Department will be decide, my lord, regarding the entitlement of the petitioner.
He's an employee where?
Is it the assistant
school.
teacher, my lord.
Gosamida.
Why has he? Why has the department asked him to be placed under administrative reform for what purpose?
Administrative Department.
Huh?
Administrative Reform, my lord.
For what
Pension
purpose?
To determine the entitlement, my lord.
What determined? It should be determined by the administrative department.
My lord, now, my lord, the pension and public defense department, my lord,
Huh?
that has been merged with, my lord, the administration reform department. So therefore, my lord, in fact, the pension department has to take a call. It is the pension department.
No, no. Who has what? Which department merged with what?
My lord, the administrative reforms and training department.
Ah,
If lordship is taking up that instruction, my lord,
yes.
lordship will find, my lord, in the second paragraph, hence you are requested to move the government in the ARTP and PG department for relaxation of rule. So in fact, my lord, basically this is, my lord, the pension and public defense department. Now merged with, my lord, the administrative reforms and training.
Said about, my lord, here mentioned it is article, my lord, rule.
So you are saying that there is no separate pension department now?
No. In fact, the pension department and administration reform department, those two departments have been merged. But their respective jurisdictional duties, my lord, they are functioning.
What is 205 and 206?
That rule is, my lord, for relaxation, my lord.
For why?
Because, my lord, she has, my lord, she has filed this case, my lord, in the year, my lord, 21. And her husband expired in the year 1983. So, my lord, Tarsem Singh has to be followed. That is there in the rule. By correcting all those things that have to be.
মানে ইন্সপেক্টৰে তেওঁলোকলৈ পঠাব লাগিব পঠাব লাগিব ডাটাটো দিব লাগিব প্ৰপ'জেলটো ইন্সপেক্টৰে তেওঁলোকে
Yes, yes.
My lord, in terms of this letter, my lord, inspector have to be submit the proposal before the administrative reform and training department.
No,
This
for
letter issued
what purpose? Proposal is submitted by which authority?
Inspector
Has
of
it,
Schools, my lord, Karbi Anglong district.
when was it submitted earlier?
6/7/23.
Where page number?
No, my lord, reading dependent
Yeah.
application. I have dependency application. They have.
That has already returned, my lord, in terms of this letter, my lord, 12 September.
No, after 6/7, it has,
This
as per
letter,
this,
12/9 issued, my lord.
so why can it not be forwarded by your office?
No, my lord, that proposal, my lord, have to be come from the concerned administrative department, my lord, parent department, my lord.
It has been sent to your department, to
No, my lord,
your,
we have already returned it, my lord, to the concerned department. In the last of this instruction, my lord, last para, the proposal, pension proposal in original is written here for your information and necessary action.
yes, madam, get the instructions. Get the instructions. So what is the job of the pension department?
Pension department, my lord, after the ascertaining the ascertainment of the pension entitlement, my lord, then my lord, pension department can proceed.
Who will ascertain?
My lord, concerned parent department, my lord.
They have
Regarding the
already sent
service
a
and
proposal.
efficiency and all, my lord.
They have already sent a proposal.
No, my lord, that proposal has already returned, my lord.
Why?
12
Because, my
September
lord,
2023.
not well, sir. Because, my lord,
Our
that
letter
have to be
was
come from the
5/10.
department to directly administrative reform department, my lord.
Lordship, our application was 5/10/2023. Lordship, this, he's referring to 12 September 2023. After that, we have sent the application.
Where is your application?
It's with
After sending it back, you have again resubmitted it.
Lordship, our last letter was 5/10/2023. Our application for relaxation.
To whom? To which department?
AR Lordship, is to ARTP and PG department, Lordship. Last occasion, Lordship, on 19/12/2023. I have
Yes.
submitted, Lordship.
Now, who is for the ART?
ART, my lord, I can represent. Well, my lord.
You see the last order, it is
My lord.
recorded that it has already been submitted.
My lord, ART is not a party, my lord.
No.
I have
Need not be a party.
one question. The definition. We have that letter. Yes. Your letter. This is again sent to the director only, na? This letter, my lord, নাই দিয়া, no, এখন মই পোৱা নাই।
Yes.
But if I get the copy of the, from that letter, my lord, I can obtain instruction from the concerned department, my lord.
Do you have a copy, madam?
Lordship, today I don't have it. Lordship, today we meet the case. Lordship, with the court is the file is.
Matter be listed after 1 week, enabling the respective standing councils, Mr. P. Soikia appearing for ART,
My lord.
P,
ARTP and PG.
PG, Department Government of Assam, and MS Kemprai appearing for Karbi Anglong
5 and 7.
Autonomous Council to complete their instructions with regard to the proposal stated to have been submitted by the concerned department to the Department of ARTP and PG, Department Government of Assam. The status of the proposal for pension sent by the administrative department in respect of the petitioner, status of the proposal in respect of the petitioner, sent by the administrative department be placed before the court by the next day. List on 16th. 16th.
Yes.
Lordship, here on the last occasion, the record was produced, Lordship. The only thing is that the proceeding record was not there. So Lordship was directed to produce that record of proceedings, Lordship. So that instruction, that record is awaited, Lordship. Otherwise, the petitioner, the only grievance here was, he has already been reinstated. Now,
Reinstated is so far is okay, my lord, but the
only grievance-
one increment, stoppage of one
Only,
increment,
the
that is
only-
my on that, my lord.
Only grievance remains is that stoppage of one agreement. So that Lordship, that proceeding record, we have called for Lordship. Instruction is given, Lordship.
You are challenging the proceedings now. What are you challenging here?
My lord, there was no such anything was found against me, my lord. The inquiry report that was submitted, and I relied, my lord, the Annex 13. That was, my lord, the
Now, against that, there is an appeal. Disciplinary authority has passed an order,
this is, my lord, disciplinary authority has passed an order by which
stoppage of one increment.
one increment, that is an inquiry officer also. The on the basis of the inquiry report, my lord, that is submitted,
Very well.
where it is stated that stoppage of one increment, but it was specifically stated that there is nothing found except I was suspended for a long period of 8 months.
Now, why have you not gone in appeal? There's an appellate forum.
At that time, my lord, appeals were not filed, my lord.
You filed your appeal.
But then now the petitioner is a verge of retirement, my lord, just, my lord, 6 months is left in his hand, my lord.
We'll direct them to dispose of your appeal. When there is an alternative statutory remedy, not
That is
just
true,
any
my
remedy.
lord, but is it not a mandatory that I have to, my lord, is some
It is
efficacious
mandatory.
remedy I can come to the
No,
court
no,
also.
it is ordinarily mandatory unless you want to say that there is no appellate forum at this or the very the very initiation of the proceeding is illegal or unauthorized.
No, because, my lord, one factor is there, my lord.
Hmm.
I was suspended with the, my lord, subject to the condition of the approval. So there was no approval for 10 years. I was reinstated. After reinstated, the approval has come. So that is was one of the, my lord, ground. During the period, they conducted the inquiry, the suspension period, that was never under approval.
No approval for what? For
But there is a
suspension.
condition, my lord. Approval, because my appointing authority was not the, my lord, the DE. So I was appointed by the director, so that was under the approval of the director, that's what I was put under suspension.
Hmm.
So that was never come. I was, my lord, inquiry was concluded, and when the, my lord, I was reinstated with the, my lord, the stoppage of one increment, then, my lord, I filed one writ petition before your lordship. When the notice was issued, then they realizing mistake, they regularized my suspension period. But the stoppage of one increment, that is in continue. So facts is this, that whenever my regularization was came, at that time also, my lord, my suspension period was not approved, my lord.
No, whatever it may be, now it has been regularized.
Now regularized.
Now
my lord.
regularized.
But the period, my lord, that was suspended, my lord, that was not approved during that period for 10 years.
No, so therefore you are challenging the very disciplinary proceedings.
Yes, my lord. So kindly have a look at the page, my lord, the annexer 10. The lordship will very clear on the basis of which, my lord, lordship directed to report my lord, submit the proceeding of the inquiry officer, my lord. The annexer, my lord, at page 40, your lordship, no.
39.
It is page 39, my lord. Annexer 10. Kindly have the inquiry report, my lord. This was the inquiry report. And that was also in violation of Rule 9. There was no any list of witnesses, no any document upon which they rely. When my so-called and suspension order was issued. Without following any procedure of the assignment.
So therefore you file an appeal. All these things can be looked into by the appellate authority. This will require examination.
Thing, my lord, that but a specific period, my lord, after that, my lord, because just it is 2 February.
We will direct them to complete
Within 1
dispose
month,
of the appeal within 30 days.
And, my lord, highlighting these facts also, my lord, because the.
Whatever you want to urge.
My lord.
You are open. It will be open for you to urge everything before the appellate
That is
authority.
true, my lord. Even then, my lord, I prayed, my lord, that to be highlighted in the lordship order so that I can
Which-
for the entire thing before the court.
You have been served with a copy of the inquiry
No,
report?
I was not even served with a copy of the inquiry also. That was I later on I procured.
No, Lordship, perhaps the inquiry report
I
has been served.
specifically.
The only thing was that on the last occasion, while perusing the record, that only thing was not there, Lordship, that proceeding record was not there.
No, inquiry report was not submitted to me, my lord.
Inquiry report,
Not served to me. That was specific pleading.
Where have you stated?
This is my lord, para 10, I have specifically stated in the bottom. That is also violation of Rule 7. Para 10 of my petition, my lord. Last but 3 lines. Without furnishing the copy of the inquiry report to the petitioner violating the provisions of Rule 7 of the Rule 1964. They have violated everything from the beginning.
Have you served the inquiry report, Mr. Sharma?
lordship, that I need to verify.
They cannot show these that things, my lord. I hope.
Because in this matter, lordship, the affidavit has not been filed. The only thing was the record was called for. And on the last occasion, when the record was, hearing lordship, the proceeding record was not there.
There is the specific ever meant that the inquiry report was not served. Then how will he go in appeal?
Lordship.
How will he go in appeal if you don't give him the inquiry report?
No.
As per the last order, the Standing Council Elementary Education was directed to place before the court the relevant files relating to the inquiry proceedings conducted by the inquiry officer, pursuant to which the penalty of stoppage of 1 increment has been imposed, comma, the Learned Standing Council submits that these records, although called for, have not been received. Praise for further time. Stop. It is submitted by the Learned Council for the petitioner that there is a categorical averment made in para 10 of the writ petition that the inquiry committee, after completion of the inquiry, forwarded the report to the disciplinary authority without furnishing a copy of the inquiry report to the petitioner, violating the provisions of Rule 7 of the Discipline and Appeal Rules 1964. Stop. Mr. Sharma, Learned Standing Council, is unable to apprise the court whether the inquiry report was indeed submitted to the petitioner. Stop. On the next date fixed, the Standing Council, besides producing the relevant records pertaining to the inquiry proceedings against the petitioner, will also inform the court, will also place materials before the court to support their contention that the inquiry report was served on the petition prior to imposition of the penalty of stoppage of 1 increment. List again on
After 2 weeks, lordship.
the 26th
Lord, 2/6, my lord.
of February.
Earlier affidavit, my lord, there is a 2 writ petition. One was, my lord, already disposed of last week, where they have filed the affidavit. Same thing, my lord, they are not denying that, my lord, that was submitted to me. Same thing, my lord. They simply say.
Have they
there is communication between the
have they
parties.
made an averment to say that it was not served?
That nothing is specifically, my lord.
So
In
let
this nothing
them
is-
get the records. Let them
nothing
get
is
the
there
records.
In the earlier affidavit. Mass application.
In this case, instruction is sought for.
Lordship, I pray for some accommodation, lordship, 2 weeks.
Matter be listed after 2 weeks as it is submitted by Mr. P. N. Sharma that the
Next
instructions called for have not yet been received. Mr.
Arya Ahmed.
R.A. Ahmed appears for the writ petitioner. List after 2 weeks.
Actually, next item.
Lordship, here, Lordship, the proposal has been received from the office of the district elementary education officer, but some clarifications were required. So now the director has instructed the DEO to clarify and submit additional document. So here also, Lordship,
Same order.
Lordship, similar.
List after 2 weeks.
Lordship.
Okay, in this case, Lordship, the petitioner's Lordship salary has not been paid even in the current salary also, Lordship. And the respondent, Lordship, was directed, submitted the affidavit of positive withstand that petitioner is not in regular in his duty, Lordship. I have also submitted, Lordship, the reply, Lordship. And on the last occasion, Lordship, there was a direction to the sending also Lordship to take instruction regarding the proposal which was allegedly Lordship served on the petitioner, Lordship. Lordship, my
Yes.
Lord, as far as the last order, compliance with the last order is concerned, my lord. My lord, I've just received the instruction from the BDO, the concerned block, Hapeghati Development Block. She is the show cause notice, which is annexure A, my lord, which is there in the affidavit of opposition at page number 102.
Yes.
Show cause notice dated 28th of December 2022 was, my lord, WhatsApp to the petitioner, my lord, and he has duly received it as well, my lord. If needed, I'll file it on affidavit.
Your WhatsApp.
WhatsApp, my lord, and he has taken cognizance of it.
Under
Service
what provision can you say that you serve notice by through WhatsApp?
but electronic mode of communication is also acceptable, my lord. So summons can be
Where? Show us your government notifications, office memorandums that it is possible. Has the government issued any memorandums or notification circulars?
my lord. There's a section, my lord. I mean, I'm just giving an example, my lord. Section 72, which talks about tendering resignation and then withdrawal of resignation. So resignations can be tendered as well as withdrawn by either post, courier, or electronic means are also acceptable.
So electronic means will ordinarily
Considered.
email would have sufficed, but WhatsApp.
That is the instruction that I have received from the PDO that.
and Lordship, this notice, Lordship,
Why was it served through WhatsApp?
was allegedly served, Lordship. This is also issued, Lordship, after filing of this petition, Lordship. And after
When was the WhatsApp sent?
My lord, 30th of December 2022.
30th December.
30th
When the
December.
notice is issued on 28th.
28th, my lord.
What was the difficulty in sending a proper notice?
My lord, even if they have sent or not, that is something which they have not given us any written instructions. This is what they have. I'll file an affidavit to that effect, my lord, as to what all modes were implemented before opting for the WhatsApp.
when my lord the petitioner is not getting his current salary also, Lordship. And the video is getting everything, Lordship.
Have you filed any affidavit?
My lord, we have.
I have filed, Lordship, I have filed the reply.
2 affidavits, my lord.
What have you stated in your affidavit?
My lord, one affidavit is by the secretary and one is by the BDO.
No, please take us one by one.
Video to them. Hundred and is complete.
How did you furnish your joining report?
Lordship. The petitioner, Lordship, went Lordship, and Lordship, I have stated. Para 6 Lordship, the petition, Lordship.
Yes.
The petitioner says that as he was released from Udarban Development Block of Qatar District on 27/12, he went to Sapekati Development Block to submit his joining report, but unfortunately his joining report was not accepted by the concerned block development officer. In this regard, the petitioner, by submitting a representation letter, was informed the same to the respondent authority. Subsequently, his joining report letter also was accepted, and accordingly he was been continuing service. Lordship, his joining report was also Lordship sent by this presentation also. Lordship, I have annexed this presentation, Lordship. Pay the presentation is Lordship, annexure E Lord. Page Lordship.
What is your prayer is only for release of regular monthly salary?
Salary, Lordship. Lordship, the video is not willing to allow the petitioner here, Lordship. This is the main thing, Lordship.
My lord would notice that from 27th of December.
And after,
2020
Lordship, after receiving the notice from this court, Lordship, tribal court, Lordship, the video release, Lordship, salary, Lordship, from the month of, Lordship, I have stated, they have also stated in their affidavit, Lordship. I have stated in my reply, Lordship, paragraph 4, Lordship. Now, this is required, Lordship, from the month of January 2022 to March 2022 and December to current salary, Lordship, the petitioner is entitled, Lordship. Only he has released salary from April 22 to November 2022.
Your representations have remained pending or what?
Lordship,
Who has filed this representation? Page 34 onwards?
page 30.
34, 34, 35, 36.
Yes, Lordship. Page 34, Lordship, the principal secretary.
So what orders have been passed?
Lordship, this has been submitted, Lordship, when his joining report was not received, Lord. Page 34. This representation was submitted. And the last representation, page 36, Lordship, when his salary was not allow, releasing, Lordship, he has submitted this representation, page 36, Lord.
What has happened to the representation?
Nothing, Lord.
My lord, the representation at page 35 is relevant, my lord, because it is directly linked to the prayer in his writ petition, release of arrear of salary.
Hmm.
So the direction may be given to the secretary to dispose of the writ petition, keeping in mind the unauthorized absence period as well, from
And lord-
December 22 to March next year. To be disposed of.
Lordship, I have carefully stated how the video, Lordship, has treated with the petitioner, Lordship. I have stated in my reply, Lordship. If the petitioner is not continuing duty, Lordship, from the date of joining, Lordship, then the question of release of the some months of salary does not arise, Lordship.
We
But he is released, Lordship.
heard learned counsel for the
I am
parties.
advising.
This writ petition is filed by the petitioner who is employed as an extension officer credit under the Panchayat and Rural Development Department. Stop. Presently, he is employed and posted at Udarband Development Block.
Oh, Lordship, presently, Lordship, Papakati Development Block.
Presently posted at Sapekati Development Block, Soraido district. Stop. While the petitioner was serving earlier under the Udarband Development Block and was allowed to hold the charge of Block Development Officer Katigora Development Block of Pachar district, he was placed under suspension by the order dated 6th of August 2021. Stop. Subsequently, by order dated 8/12/2021, the petitioner was reinstated in service and posted at Sapekati Development Block, Raidu district. Stop. Although the petitioner, it is submitted that although the petitioner, it is submitted by the learned counsel for the petitioner that although the petitioner submitted his joining report and had been continuing in his service at Sapekati Development Block in Soraido district, but his salary from the date of joining has not been released to him, allegedly by the BDO, namely the respondent number 4. So, the learned counsel for the petitioner submits that the joining report has not been accepted by the BDO.
Initially, no.
Huh?
Initially not accepted, Lord.
Initially,
Yes, Lord.
initially not accepted, and he was not allotted any work. So subsequently, the same was received by the BDO, accepted by the BDO, but notwithstanding that, his monthly salary for the concerned months have not been released. So, Mr. Henrik, learned counsel appearing to the CNRD submits that the department has filed affidavits, and on the basis of the affidavits, it is submitted on the basis of the averments made in the affidavit. It is submitted that the petitioner has refused to attend to his work, and consequently, his monthly salary was stopped by the BDO for not attending to his official duties. Stop.
few months of salary was released, Lordship.
Upon careful perusal of the petition, it is seen that there are several representations preferred before the Commissioner and Secretary Department of PNRD, which preferred by the petitioner and which according to the petitioner has not been disposed of. Stop. In the affidavits filed, there is no averment relating to those representations filed before the Commissioner and Secretary Department of PNR. Stop. Having heard learned counsel for the party, it is seen that the matter is pending before the court for a direction to the respondent authorities for release of monthly salary. The petition. Stop. The dispute has arisen as to whether the petitioner had joined in his service as per the order of transfer and has been attending to his duties. Stop. While the petitioner claims that he has been regularly attending to his duties, the department in their affidavits filed by
My lord, the commissioner and the BDO, 1 and 4. Secretary and the BDO.
Secretary Department of the Department of Panchayat and Rural Development, as well as by the BDO, concerned BDO, has disputed the contention of the petitioner that he has joined in his official duties and has joined in his official duties. Rather, it is averred that the petitioner did not join in his duties and absented himself from his official duties in spite of several intimations being issued by the BDO. Stop. Since the dispute raised by the petitioner, since the dispute between the petitioner and the department appears to be essentially of facts, considering the fact that there are representations seen which are stated to be pending before the Commissioner and Secretary Department of Panchayat and Rural Development, namely, is it Commissioner or Principal Commissioner?
Commissioner.
Huh?
Lordship, it is the Principal Secretary, Lordship. It is the Principal Secretary.
Principal. No, your representations are filed
Under
for whom?
Secretary, Lordship. Page 36.
36.
Under Secretary, one is Under Secretary. And another is Principal Secretary. Page 35 is Principal Secretary.
Principal Secretary.
Dot.
This court is of the view that the matter needs to be decided. The court is of the view that the writ petition can be disposed of with a direction to the respondent number 1, namely the Principal Secretary, Government of Assam, Panchayat and Rural Development, to look into the grievances raised by the petitioner by way of his representation stated to have been filed on 21/6/2022. The respondent 1 will thereafter
Taking in cognizance the unauthorized leave period.
hear the matter and pass appropriate orders, appropriate speaking order. Stop. Any order that is passed, copy thereof shall be served on the writ petitioner. Stop. The entire exercise be completed within a period of 30 days from the date of receipt of a certified copy of this order.
But and his monthly salary may be released, Lordship, immediately. He is not getting
If upon examination, verification of the
subject to
matter, it
condition that he
is
will be
found that
available in the
the monthly salary has not been released to the petitioner, then the same shall be released without further delay.
May I please your lordship. My lord, matter relates to non-payment of retirement benefits, my lord. And this is the order dated 2023, my lord. Lord, the government taking time for submitting complete instructions, my lord, since last 1.5 years.
Kundu issue.
Yes.
My lord, I have certain instructions with me, my lord. As far as the issue of pension is concerned, my lord, as was raised on the previous date, my lord, he's a DRDA born employee, and as far as DRDA born employees are concerned, my lord, they're not entitled for pension, my lord.
On what basis?
My lord, there's a memorandum which has been issued by the finance department. In fact, there was a case, my lord. My lord, I have the instructions which ought to be read with this judgment, my lord. Vipul Chandra Guhai. I have a copy of the.
You
instructions that-
explain to us, why you sending all the papers here? You explain to us what is there in the judgment, what is there in the office memorandum.
My lord, their grievance in this particular writ petition was that they ought to be governed by the pension rules 1969. But the finance department, my lord, had issued a proposal that, but the finance department had turned down the proposal, my lord, that they would be governed by the new NPS scheme, my lord. So whatever service period, whatever period they had served in the DRDA, that won't be counted.
Their original appointments were
DRDA, my lord.
under DRDA.
DRDA bond, subsequently absorbed in the year 2017.
So if
So
they
they would
absorb
be,
their services earlier, will be wiped out.
my lord, as far as pension is concerned,
Huh.
and as far as DCRG is concerned, my lord, there was a cabinet meeting, a draft memorandum, my lord, was being considered to pay them for their past services which they had served in the DRDA bond establishment. But as far as pension is concerned,
Where is that
2000
memorandum?
my lord, no, I don't have a copy with that of that.
My lord.
Finance department would have, but it's noted, my lord, the submission in this particular judgment.
The judgment is to what effect?
Uh, pertaining to DRDA employees only, my lord, they had sought for the leave of this court to be governed by the 69 pension.
That has been negated.
That has been negated.
Are you familiar
My
with the
lord,
judgment?
let us see my prayer, my lord, my prayer in the writ petition. I am not praying for pension, but my retirement benefit, that is gratuity, my lord. That come gratuity, that come retirement, gratuity, leave encashment and insurance, my lord, money, my lord. So that may be, my lord, payment. I am not praying for pension.
Are you aware of the judgment?
My lord,
There was a representation which you had to file.
Are you aware of the judgment which the respondents are pressing into service?
no, my lord, that does not, my lord, I have to Vipul Chandra Guhai. After some time, my lord, I'm done.
At 2 p.m.
My
My lord, the petitioner was convicted by the learned additional session judge Hailakandi. Thereafter, my lord, we preferred a statutory appeal along with the IA. The appeal was admitted, and in the IA, both the conviction as well as the sentence have been stayed by this honorable court. However, my lord, subsequent thereto, the authority.
Convicted in a criminal proceeding?
Yes.
In a criminal matter?
Yes, and sentenced to 7 years imprisonment.
Ah.
Now, pursuant to that, I preferred a criminal appeal along with a IA for stay of the impugned judgment as well as the sentence. So, my lord, this honorable court admitted the appeal and suspended the operation of conviction as well as the sentence, my lord. Now, my lord, despite there being a stay order operating, the departmental authorities have dismissed me summarily in view of my conviction, my lord. As per the law holding the field, once the sentence as well as conviction is stayed, any disqualification emanating from such conviction or sentence my lord, becomes inoperative, my lord. So I have to be taken back, my lord. But you will kindly come to the stay order, my lord. It starts at page 88 and the operative portion is at page 91. Order dated 16/9/2022. The second paragraph, page 91, my lord.
Yes.
Second paragraph, my lord. Since the connected appeal is admitted for hearing, the judgment and order dated 30/9/2022 passed by the learned additional session judge Hailakandi in sessions case number so and so shall remain stay. So both the conviction as well as sentence has been stayed. Now, my lord, will come to the next page, that is the impugn order, page 92. The penultimate para, my lord. After careful application of mind and perusal of honorable court judgment and relying upon the provision above, I being the competent authority, dismiss Constable M. Mitay Nangba, that is the petitioner, of SB organization from service with effect from the date of court judgment dated 3/9/2022. So 3/9/2022 has been stated, my lord, in the preceding page I have shown. Now, lordship will kindly come to the affidavit. What is the stand, my lord?
You have been dismissed without holding any inquiry.
As per my lord 311, first exception, if any conviction is there in a criminal proceeding, they can dismiss me summarily, my lord, without any giving any hearing. But what will happen if the conviction as well as the sentence is stayed? Then I will rely on the judgment of the Supreme Court.
Then you'll be reinstated back.
Till that not reinstated, my lord. Till that not.
No, it's only state.
No, yes. That's why I
Criminal
am-
appeal has been allowed.
No, appeal is admitted, it is not
then-
decided. Let will kindly peruse this judgment next. What will be the effect of disqualification emanating from such conviction matter? One small question.
So in this case, the instruction received, lordship, for
No, no,
the
they
quick time,
filed-
lordship.
They file affidavit. my
Lordship,
lord.
this instruction received, lordship.
What effect?
Lordship, actually, D not appeared in this case, lordship, senior.
Yes.
Yes, my lord will come to page number 123, paragraph 16. It is, my lord, 2018 SCC, page 114, paragraph 16, my lord. May I read it, my lord? At page 123.
Yes.
These decisions have settled the position on the effect of an order of an appellate court staying conviction pending the appeal. Upon stay of a conviction under section 389 CRPC, the disqualification under section 8 will not operate. The decisions of so-and-so versus so-and-so conclude the issue. Since the decision in so-and-so, it has been well settled that the appellate court has the power in an appropriate case to stay the conviction under section 389 besides suspending the sentence. The power to stay a conviction is by way of an exception. Before it is exercised, the appellate court must be made aware of the consequences which will ensue if the conviction is not stayed. Once the conviction has been stayed by the appellate court, the disqualification under section so and the disqualification will not operate. Under Article 102 and 22, the disqualification operates by or under any law made by the Parliament. But this is very important. Disqualification under the above provisions of Section 8 follows upon a conviction for one of the listed offences. Once the conviction has been stayed during the pendency of an appeal, the disqualification which operates as a consequence of the conviction cannot take or remain in effect. In view of the consistent statement of the legal position in so and in decisions which followed, there is no merit in the submission that the power conferred under the appellate court under section 389 does not include the power in an appropriate case to stay conviction. Clearly, the appellate court does possess such power. Moreover, this is also very important matter. Moreover, it is untenable that the disqualification which ensues from the conviction will operate despite the appellate court having granted stay of conviction. The authority vested in appellate court to stay a conviction ensures that a conviction on untenable or frivolous ground does not operate to cause serious prejudice. As the decision in so-and-so has clarified, a stay of conviction would relieve the individual from suffering the consequences inter alia of a disqualification related to the provisions of so. So in my case, my lord, due to my conviction, I have been dismissed summarily. But
You
prior
have
to,
to hear the matter, Mr. Patwari. You will have to hear the matter.
Ma'am,
Your argument that merely because there's a stay, you'll get back into service.
no, Lordship, the stay has been granted on 16/6 and subsequent to that I have been dismissed. My lord. Lordship, kindly consider one small paragraph of their affidavit. my
No,
lord.
we'll hear the matter. We'll hear the matter. Yes. What about your affidavits?
They have filed affidavit, my lord.
You filed
Yes, that's one paragraph I want to rely, my lord. Just one paragraph.
one paragraph of the judgment.
No, affidavit filed by the respondent.
Yes.
It has been filed by one Ripul Das, page 96, running page, my lord. Page 96.
96.
Yeah.
Yes.
Has the lordship got it?
Yes.
This is the affidavit filed by them. Lordship will kindly turn to para 6 and para 9 annual, small para.
Hmm.
That with regard to the statements made in paragraph 5 of the writ petition, the defendant begs to state that as per records, certified copy of the judgment and order dated 3, that is the conviction order, passed by the learned Additional Session Judge Hailakandi, so was received at SB headquarters on 16/9/2022 from Superintendent of Police, so. Now, Lordship kindly turn to para 9, next page. That with regard to the statements made in para 9 of the writ petition, the deponent begs to state that it is a fact that petitioner had submitted a representation along with a copy of stay order dated 16/9/2022 in the Honorable Guwahati High Court to the judgment passed by the learned Additional Session Judge Hailakandi in IA criminal number so and so. A direction in this regard from the Honorable Court would be convenient for the authority to consider the plan. And I've submitted the stay order. Subsequent to that, they
When is the impugned order passed?
at writ petition, my lord.
Impugned order?
Yes, my lord, that's page 92. I've just shown. After passing of the stay order, my lord. Stay order is at page 91 and impugned order at page 92. Page 92 of the report. Stay order at page 91. The penultimate pyramid. Stay order is of 16/6, they dismissed me on 16/9 and they dismissed me on 19/9. So my humble submission before your lordship is, since the entire judgment and order including a conviction has been stayed, any disqualification emanating from such conviction is inoperative. So they have to take me back. That is my humble prayer, my lord, and they have left it to the court, my lord.
But page 91 stay order, they obtained this, it was not available when the order of 19/9 was passed. It was not available before the authority. Because, no, because the certified copy of the 90. In fact, not, the appeal has been admitted and the judgment has been stayed. Normally, my lord, the sentence, operation of the sentence is stayed, my lord. Conviction remains. But lordship may give us 3 days time, my lord. Lordship may hear the matter.
Matter be listed again on 22nd February.
Only thing is he's out of job, best, no salary, nothing, my lord, facing serious hardship, my lord, since 2022.
All right.
Deeply obliged.
Follow.
Can I take back the copy of the judgment, my lord?
No, you cannot. You note it down and you take another copy. You're punishing one copy. Yes.
May I please, Lordship. Lordship, the matter is relating to the payment of arrears salary, Lordship, with effect from 15/9/20 to 28 to 21, Lordship. Now, Lordship, order dated 10/8/23, Lordship. I filed an IA to complete the finance department as the respond number 8, Lordship. And the respond number 4 filed affidavit, Lordship.
FW party.
Paragraph 3 of the affidavit, Lordship.
Para 3 of
the affidavit filed by the respondent number 4, Lordship.
yes.
Lordship.
Please
That the
read.
answering deponent actually state that arrears salary in respect of Dr. Motiur Rahman Matabut Sancho with effect from 59/22, 28/2/21 would be released by the Director of Health Service FW, Lordship. As at that relevant time, the petitioner was serving as Sancho Medical and Health Officer FW Nogao, which is under the Director of Health Service Sancho. As such, the matter is not related with this Directorate, Lordship. In my writ
It
petition,
is
Lordship,
to be released by Director of,
Health Service FW, Lordship.
and this affidavit is filed by?
The Director of Health Services, Lordship. These are two directorates, Lordship. He has to impede the Director of Health Services FW, Lordship. It's a necessary party, Lordship.
He has pleaded
Lordship.
Director of
Health Service,
Services,
Lordship.
Lordship.
Health Service.
Lordship.
And this is Director of Health Service FW.
Okay.
Two different directorates.
So you are impleading, you have filed your IA.
No,
I'll
Lordship.
file IA, but I file one IA, Lordship, to implement the Finance Department as the respondent number 8.
No, but before that you implead the FW.
Lordship. I'll file an IA.
Learned counsel for the petitioner prays for 2 weeks' time to file necessary application for implement of Director of Health Service within bracket FW,
Okay.
Government of Assam. As also the Finance Department. List after 2 weeks.
Highly open.
May I please, Your Lordship? Lordship, on 2nd of February, the proposal was resubmitted, Your Lordship. Because on the earlier occasion, there were some mistakes, so they had asked for a resubmission from the Inspector of Schools, Your Lordship. So it was submitted on 2nd of February. The Inspector of Schools has resubmitted the proposal to the Director of Secondary Education.
Director.
Lordship.
So let us wait. It is submitted by MSD Mushahari, Learned Standing Council, Secondary Education, that the Inspector of Schools,
Lordship.
from which district?
Amingaon, Your Lordship, Kamrup Rural.
Amingaon, Kamrup Rural has submitted the fresh proposal for
Area salary.
area salary of the petitioner before the Director,
Lordship, to the Director of Secondary
Secondary Education on 2nd of February,
2nd of February, 2024.
2024. Learned Council for the Secondary Education submits that matter be deferred by another 2 weeks, 3 weeks, to enable the respective department to apprise the court on the status of the proposal submitted by the Inspector of Schools. Stop. MS A. Talukdar, Learned Counsel for the petitioner, does not object. Placed after 3 weeks.
Lordship, can I pray for a date, Lordship?
6th of March.
Obliged, Your Lord.
May I appeal? Lordship, may there is earlier order dated 29/11/2023, Lordship.
May it please your Lordship. My Lord, we have received the instructions from the BTC authority and matter is under process, my Lord. Within Sunday, we will release the pension.
BTC has done their job.
BTC has
New
done.
proposal has been,
1812, my Lord, we have received it.
as per my instruction, Lordship, the proposal has been received by the Director of Pension.
That is what he says.
That is pending there, Lordship.
Yes, it is submitted by MS RB Bora, Learned Standing Council PTC, that proposals have already been forwarded to the Directorate of Pension.
Pension, my Lord, on 12/8, 1812.
On?
1812.
On 18/12/2023. Where Mr. P. Soikia, Learned Standing Council Pension Department, does not dispute the submissions made by Learned Standing Council BTC. He submits that matter be deferred by 2 weeks, enabling him to complete his instructions on the proposals.
My Lord, that is
submitted.
under process as per my instruction, my Lord.
It is submitted that the same are under process
My Lord.
at this stage. Stop. Mr. Das.
TK.
P.K. Das, learned counsel, appears for the petitioner. List after 3 weeks,
My lord, 4 weeks, my lord.
4 weeks,
My lord. Must-
4 weeks. List on 11th March.
Obliged. Meet with the Lordship. Inspector pardons a non-payment of earned leave, Lordship. There are two petitioners.
Lordship, as per order dated 24/11/2023, my lord. Today morning, I have received up-to-date instruction, my lord, that my lord, their supplementary demand proposal, my lord, has been sent to the for cabinet's approval. Today, assembly sessions were started, my lord. And my lord, the finance department later, my lord, I will bring it on the next date, my lord.
My prayer is
And,
since,
and my lord, petitioner number 2, petitioner number 2, my lord, when this writ petition has been filed, my lord, in that time, my lord, he was not retired, my lord. He was retired on 30/9/2023. So, my lord, his name has not been sent, but petitioner number 1, my lord, his name has been sent for with other 24 employees of APCDC, my lord.
here, Lordship, I am not claiming my retirement benefit. I am only claiming earned leave, Lordship. It has been communicated to me by the managing director that it is due, but due to poor financial condition, we are unable to pay. Since, Lordship, my due is that is admitted, Lordship. The matter may be disposed of within and with a direction to pay it within a fixed period of time, Lordship.
Nope. Third, learned counsels for the parties. This writ petition is filed by the petitioners. Who are, they're still working,
No, my lord.
I now retired.
now retired, who had rendered services under the soil conservation,
No, my lord, Assam
is
Plantation Crops Development Corporation.
Assam Plantation Crops Development Corporation, and have since superannuated from service. The grievance of the petitioners are that
One more thing, my lord, I want to like to submit, my lord. My lord, petitioner number 1, my lord, he have another case, my lord, that was pending, my lord, and that case was been segregated on by last order, my lord. That is, my lord, WPC 2388 of 2020, my lord.
In that case, there is different, Lordship. There is
Yes,
no
my lord,
segregated.
he was, my lord, that he was, my lord, that in that case, my lord, he was, my lord, he was under suspension, and that suspension on order, my lord, still date, my lord, it was not been revoked, my lord.
It was, the prayer is different.
all right.
It is a segregated.
The grievance of the petitioners are that their earned leave of 332 days with effect from 1/9/2013 to 27/9/2011. In respect of their earned leave, they have not received their outstanding dues. Stop. The petitioner's claims have not been disputed by the corporation, but the corporation, by communication dated 11/11/2022, informed the petitioners that the corporation is not in a position to pay the unpaid salaries or dues the petitioners due to poor financial conditions. So, several representations made before the corporation have not yielded any results. Para. Learned counsel, standing counsel for soil conservation.
Yes, my lord, respondent number 1, 3, 4, and 5.
For respondents 1, 3, 4, and 5, submits that the affidavit has been filed on behalf of the department. You're not disputing their claims.
Oh, my lord.
Where the claims have not been disputed. Stop. Further, upon latest instructions received from the department, it is submitted that the department, parent department, which is the parent department?
Soil conservation.
Soil Conservation Department, Government of Assam, has sent a proposal for placing supplementary demand, and the same is likely to be placed before the cabinet
Approval.
for its approval. Stop. As there is no dispute on the claims made by the writ petitioners, there is every likelihood that the claims of the petitioners will be resolved upon the sanction of the supplementary demand in respect of the proposals which have been submitted before the authorities concerned. So, in view of the fact that there is no denial of the claims of the petitioners in respect of their
No, my lord, I had in my affidavit, my lord, that gratuity, my lord, 7 lakhs, petitioner, my lord.
in respect of
Yes.
their salary dues in terms of the proposals which have been put up before the government for release of supplementary demand. It is expected that once the demand is sanctioned, the claims made by the petitioner will be released subject to provisions of law.
Yes.
So, under such circumstances, we do not propose to keep the writ petition pending. The same is disposed of, directing the department to release the salary dues of the petitioners within a period of
My lord, 3 months.
90 days.
3 months, my lord.
90 days from the date of receipt of a certified copy of this order, subject to sanction of the supplementary demand and subject to the provisions of law. If subject to provisions of law, writ petition stands disposed of, interim orders, if any, stands merged.
Time applies. sir.
Please, your lordship. In this case, I want 7 days time, my lord, to obtain the instruction, lordship. As on 14 December, the department has forwarded the pension service book to offline mode, my lord.
Yes, Mr. Sharma.
My lord, along with the pension, my lord, I am
That
also
is-
some dues are also pending, paragraph 21. Because my suspension period has been regularized subsequently. So that suspension allowance, remaining amount of suspension.
What
allowance.
proposal has been sent?
Lordship, regarding pension proposal, lordship.
All right, let the pension be cleared first.
On
Mr.
14th to
Mr. N. Sharma, appears for the petitioner. Mr. R.K. Talukdar for Accountant General submits that the pension proposal in respect of the writ petition has been received. from
Not
the-
received, my lord. They have forwarded on 14/12. Whether it is received or not, I have to verify, lordship. In this letter, lordship, I'll do the needful, my lord.
Forwarded means you have received it?
Lordship, I have just now got this
Or
letter. from-
forwarded from, you have,
From the department.
has been informed that pension proposal has been forwarded by the Education Department on 14/12/2023. He, however, has no instructions as to the status of the proposal stated to have been forwarded by the Education Department. He prays for 2 weeks' time to complete his instructions. Mr. P.N. Sharma appears for Elementary Education Department. Matter be deferred to be listed again after 3 weeks. Yes.
Or that may be given, my lord. That may be given.
4th of March.
My lord.
This matter be listed again on 4th of March. Enabling the standing councils to complete their instructions.
Right, legal one. The matter relates to suspension of the secretary of a society, my lord. My lord, in this case, what happened, the show cause notice was issued on 25/1.
My lord, before the petitioner, my lord, gains momentum, in fact, may I place one order of the division bench, my lord? In fact, the issue, my lord, in this case relates to the removal of the petitioner, my lord, from the society as a secretary by the board of directors, my lord. So the question, my lord, in the connected writ petition was whether the writ petition is maintainable because it's a relation between the employer and employee in a private body. My lord, having regard to the recent Supreme Court judgment, my lord, the honorable division bench, my lord, has been pleased, my lord, to stay the judgment of the learned single judgment. So I leave it to your lordship. Your lordship may take the matter with the writ appeal, or your lordship may await, my lord.
That writ petition pertains to what? That
In
order of
fact,
the
in
learned
that
single judge?
case, he was also removed, my lord, by the board of the society, my lord.
He was
and
also a secretary.
Secretary, my lord, same case.
My lord,
Then
I think my friend is not right, my lord, because after taking the resolution by the board, another person is appointed as the in charge secretary, my lord. So it is not limited to the employee and employee dispute, my lord.
You go through this order.
No, my lord.
Have a look at this order. The issues raised in the writ petition pertain to the release of the petitioner from his post of secretary by the concerned cooperative society, namely
Uttar Boguribari Cooperative.
Boguribari Samobai Samiti, by the order of the board of directors, by board of directors resolution dated 25/1/2023, which has also been impugned. There are Mr. Talukdar, Learned Standing Council, Cooperation Department, has placed before the court the order dated so and so, passed in writ so and so,
29/9/23.
29/9/23, whereby
Read appeal 372/23.
an order passed by a coordinate bench has been suspended, placing reliance on the judgments of the apex court. Stop. The question pending. The question from a perusal of the order, it is clear that the division bench at present is in session of the matter as to whether, in respect of service conditions, in respect of services of employees of the corporation, of the cooperative society, being within the realm of private contract, whether writ jurisdiction will lie. In that view of the matter, the writ petition is deferred for 4 weeks, enabling the parties to place before the courts any judgment that may have been passed by the division bench in respect of writ appeal numbers.
Deeply
Staff to
obliged, my
propose.
Lordship, here also the director has sent the instructed the DO to send the proposal. Reminder letter has also been
Proposal
given.
already
Lordship.
sent, my lord.
Huh?
I have an estimate. Proposal already sent. Long back.
Proposal already sent. Case number
Page, my lord, 23, my lord.
23. It has already been sent in October.
No, Lordship, fresh proposal, Lordship.
Why?
Fresh proposal has been called for, Lordship. 32. My instruction says to Lord.
Is it this matter or some other matter?
In item number 32, Lordship.
Why fresh proposal?
2698, Yakopali.
Fresh proposal.
Lordship.
Call for from?
Lordship, that DO. From the DO, Lordship.
Why do you permit such incomplete instructions? What, for what purpose the
Lordship,
proposal has been called for? What happened to the earlier proposal?
Lordship.
Mr. P. N. Sharma, Learned Standing Council Elementary, submits that a fresh proposal has been called for from the DEO
For that suspension
Hailakandi
period, Lord.
by the Director Elementary Education in respect of the arrear pay and allowances claimed by the petitioner. Stop. Mr. Islam, Learned Counsel for the petitioners,
HR Ahmed.
submits
HR Ahmed.
HR. Ahmed, Learned Counsel for the petitioner, submits that the proposal in respect of the claims the petitioner was forwarded by the DEO's office as far back as 9th of October 2019, and a copy thereof is enclosed as Annexure 7, page 23 to the writ petition. stop. The respondent departmental counsel, Mr. Sharma, is permitted to complete his instructions in this respect. Stop matter be listed after 2 weeks, permitting him to apprise the court as to the status of the proposals uh, as to the claims of the writ petitioner in respect of release of AISL. Matter be listed again on 26th February.
It was not, along with the non-roll certificate, duly signed by the treasury officer. was called.
Whatever is there, you
Ah,
call
like-
for it.
Lordship, where I need some accommodation, Lordship, I need to furnish the report on the basis of which the secretary has passed the impugned order, Lordship, which was submitted by the Director of Higher Education.
Yes, Mr. Kaun.
They have taken time, as a last chance it may be granted.
Mr. D. Upamanyu Learned Standing Council Higher Education. Prays for further time to complete his instructions. Mr. Count Learned Counsel for the petitioner submits that several opportunities were granted. Therefore, this adjournment may be the last adjournment in respect of the petitioners to respect of the respondents to complete their instructions. Mr. Hassan appears for the Accountant General. Let the matter be listed after 3 weeks.
Can it be around 2 weeks, my lord?
2 weeks.
Date may be fixed.
List again on 28th February.
Highly open.
So item number 34 to 38 and 42 to 44 are similar matters, all regarding non-payment of area salaries, gratuity and leave encashment. More or less, we are admitting on that amount. We are filing our affidavit today, Your Lordship. Some time can be granted to us.
So if you are admitting it, pay it.
More or less, because there is a issue regarding that particular amount being brought from the government because there is a financial constraint. This is a corporation that we are appealing.
Question is, do you admit or you don't admit? If you
The,
admit,
the amounts we have to verify, whatever they are claiming.
it's a different issue, but
the claim as it is, that more or less.
You admit that they are
My
entitled to
affidavit will be on record, then Lordship, it will be all clear. But
and you are not, you do not have the means to pay them.
yes. And this is a second round of litigation. There were previous matters also when this honorable court had interfered, and thereafter the finance department was asked to sanction that amount. And subsequently money had come, and then those people have been paid. So now these are the new batch of writ petitions now.
So
for the same
what
claim.
happens to who's for the finance? Yes.
Since there's some amount of budget is available, my lords, and regarding if there's any shortfall, lordship, they can ask for a supplementary budget, and then after consideration, the amount can be released also, my lord. At this stage, my lords, let the
You are filing your affidavit.
Yes, sir. Today I'm requesting some accommodation for filing of the affidavit.
All right, we'll have it on Friday then.
Lordship, similar matter, Lordship has already disposed of, Lordship.
Let him file the affidavit. We'll have it on Friday.
Lordship matter can be taken, Lordship, with item
already-
number 34 to 38.
34 to 38.
34 to 38, and then 42, 43, and 44.
Court master.
Friday would be?
Take note.
Friday
List these matters again on Friday. बोले ना कि आते अपनी नंबर क्या था?
9 to 1.
Uh,
9.
no.
9 to 9.
As it is submitted that the respondent corporation will file the necessary affidavit during the course of the day.
Yes.
Yes.
Yes. Then who appears for others?
Lordship, in 42 to 44, I am appearing, Lordship.
And 34 to 38. You give the numbers to the court master.
Deeply obliged.
Finance, Mr. Choliha, Director of Welfare and Plains Tribes, Mr. Who appears?
Lordship, Ardhar is appearing in this matter, Lordship.
Tribal affairs for Ardhar.
Okay, Ardhar. Okay.
I am for the corporation, Lord.
Corporation, Mr. A. Sharma. List on Friday.
Obliged.
Wait, your lordship. Lordship, 39 and 40 similar matter, lordship, and here in 39, lordship, they are working, and in 40, they are retired person. So some financial benefit they have to get as per a notification order by the governor of governor dated 6 July 2017, Annexure A.
Affidavits have been filed,
No, lordship,
not filed.
not filed. So for one certain period, they have received, lordship.
Let them file their affidavit.
Lordship.
Respondents. Elementary education
Lordship, elementary.
as well as the finance.
Finance, lordship.
Are directed, are permitted to complete their instructions and file the necessary affidavit. List after 3 weeks.
Kindly date may be fixed, lordship.
6th of March.
Obliged, lordship.
Please, your lordship, kindly take the matter at to lordship. My senior is placed in another court.
At 2:40. Will come back at
My lord, in this case, my lord, I am a student of B Pharma at TR College of Pharmacy, my lord. I appeared, my lord, fourth semester examination on December 2022. The subject name medicinal chemistry. I appeared in the examination, I did well. However, in the result sheet, I was shown I was absent. I approached before the authority.
Respondent 2 and 3 will have to furnish the instruction, my lord, the college authority.
who appears?
Probably, my lord, he will have to take steps.
You do
Yes,
not
private
represent.
institute, my lord.
Oh, Karimganj.
Yes, sir. We register very by the
Heard.
civil,
Learned counsel for the
Well-
parties issue notice returnable for
for one I moved.
Mr. B. Gugoi appears for respondent 1. Steps on respondent 2 and 3 by registered posts and legal reports within 1 week from today. Mr. Gugoi be served with an extra copy of the
Our
report.
name may be reflected, madam.
Names of standing council health be reflected in the
Lovely.
post list of the register.
Till then, my lord, my one submission, my lord. The effect of that result.
You take steps first. You should have taken steps. If there is an interim order, you take steps. Dusty service, advance copy. In the absence of the respondents, how can we pass an interim order? Yes.
My lord, I have gone through the judgment, my lord, referred by. That is, my lord, petitioners applied for the pension under 69 rules, old rules. And a representation was also given to the authority. Representation was not considered. That's why they have approached this honorable court. And this honorable court's directed to dispose of the representation. That is the order, my lord, in earlier. The judgment they referred. My lord, my case is that, my lord, kindly see my prayer in the read petition. My lord, I have prayed for payment of gratuity, leave encashment, group insurance. This is my all my personal money, my lord, I have deposited. These are they are to release this, my lord, this monies, my lord. I am not claiming for pension, my lord. Pension is, that matter is pending, my lord.
No affidavit.
No affidavit has been filed since last 1.5 years, my lord. Though they are taking time, my lord, but no affidavit has been filed.
Yes.
Your lordship, we have received the instruction. In the meanwhile, we are asked to bring the instruction regarding cabinet decision, your lordship. That has yet not been decided by the cabinet, your lordship.
What is to be decided?
Your lordship, regarding
counting of their past service in fixation of DCRG. Because before 2017, they were working DRDA. DRDA. In the 2017, they were.
They're working.
Otherwise, we had the instruction, Your Lordship. The instruction is that, Your Lordship, while she was in DRDA, she was promoted to grade 1 stenographer. The government stand is that in the district level and in the DRDA, there is no such post of grade 1 stenographer's post. And since it is a gazetted post, the APSC has to be recruited. Selection should be made by the APSC. So, DRDA authority in the, Your Lordship, Karbi Anglong district, Your Lordship, it is improperly promoted her to the post of grade 1 post. Stenographer grade 1, Your Lordship. So that is why, Your Lordship, the department is awaiting the personnel department's response, Your Lordship.
Where is the order of promotion to grade 1?
Your Lordship,
My lord, order P, annexer P4, my lord. Annexer P for page 16.
Grade 1.
Srimati Ronke Goy, stenographer grade 2 is promoted to the post of grade 1
This is
by
by
upgrading
principal
the present post
This
of
order is by
stenographer.
principal secretary.
yes, Your Lordship.
This order is by principal secretary.
Principal Secretary of the Karbi Anglong Autonomous District Council, Your Lordship, he has issued this because he was the project director of the DRDA in the Karbi Anglong district.
That was
This-
order
that
passed
is-
for in 2015, my lord.
But then, Your Lordship, she was working in a non-governmental organization, Your Lordship. DRDA is a society, Your Lordship, not the government.
But under the government,
Your Lordship,
under the government,
Your Lordship,
run by government officers,
Your Lordship,
funds given by the government.
Your Lordship, yes, under the scheme. Under the scheme is a registered society, Your Lordship. And Your Lordship, the project director, in case of the 6th schedule area, Your Lordship, project director is the principal secretary. Karbi Anglong, in the case of Karbi Anglong, the principal secretary is the project director. In other districts, Your Lordship, the project director, so far as project directors are concerned, they are employees of the government. They joined as project director on deputation.
Now, why these amounts are not released? Gratuity, leave encashment, group insurance.
Your Lordship, so far as this year is concerned, it is, Your Lordship, the Your Lordship, the the DRDA-born employees are eligible for DCRG as per office memorandum dated 1/2/2021 with effect from the date of their absorption against the vacant sanction post. She was absorbed in a stenographer grade 3 post.
After being promoted to grade 1.
The grade 1, it was wrongly promoted by the DRDA authority, not by the government, Your Lordship. She came to the government, came to the government
Absorption.
department under the government, Your Lordship, in the year 2017 only. Before that, she was working here.
Which order? Which order?
My lord,
By which order?
page 17, my lord.
17.
Page 17. She was promoted in 2015 and she was absorbed in 2017, my lord, against the sanction post. Against sanction post, my lord.
Post were created,
The
Your
same
Lordship.
post.
Grade 3 post were created in the stenographer. Your Lordship, she was absorbed, Your Lordship. 91 personnel posts were created, Your Lordship. Out of 91, 25 stenographer posts were created.
It does not say grade 3, grade 1. It says
Your
stenographer.
Lordship, they kindly see there is another notification. It was issued on 31st of August 2016, Your Lordship. That is our instruction, Your Lordship. As per our instruction, Your Lordship. She was working in payment 4 absorbed in payment 2, Your Lordship. She accepted it, given the undertaking, Your Lordship.
And then also she is entitled to whatever benefits,
Yes, and in payment 2, Your Lordship.
whatever, but why have you released that?
That because the dispute regarding the in whose payment it will be fixed, Your Lordship.
It is your case that she is absorbed under payment too.
We have sent it to the personal department. We are awaiting for their response, Your Lordship.
You have absorbed it. Now you want your
We
doubts
have
to
no
be.
objection if we count it from the 2007, from the date of her absorption in
You-
payment 2. We have no objection. We will release it, Your Lordship.
So who's stopping you from releasing it?
We will release it.
You
In
release
payment
that,
2.
you release that payment.
Yes, yes.
And the
That-
further
that-
claims of whether it is with effect from the date she was absorbed in grade 1 will remain. Meanwhile, you release that amount.
Yes, yes.
Directly dispute.
Yeah, that's it.
Well, it is her property. The person has deposited money.
We are not closing your petition. We are saying that let them release it. Whatever they, according to them, there is no
My lord,
dispute,
my
let
lord.
that amount be released.
Yes, yes. We have no objection.
I heard done at counsel for the parties, Mr. Learned Regional AG appearing for PNRD department submits on instructions that is, as per the instructions received, petitioner was absorbed in the PNRD department from DRDA in a vacant post of stenographer grade 3 stop on with effect from 1/8/2017. However, the claim of the petitioner is for release of the CRG payable to her in the payment, which is in the pay scale of grade 1 stenographer. This issue, according to the Learned Additional AG, has been placed before the Department of Personnel for their views. Stop. Learned Counsel for the petitioner submits that the prayer in the writ petition is for release of retirement benefits like gratuity, leave encashment, group insurance, etc. There is no reason why this amount which belongs to the petitioner has not been released till date. Let the department bring on record their clear stand in respect of the claims made by the petitioners by filing an affidavit. In the meantime, the amount of the retirement benefits, which according to the department, the petitioner is entitled to, may be released during the pendency of the writ petition.
Within a month, my lord.
Expeditiously. Let the matter be listed again after 4 weeks.
Your Lordship, the grade 3, Your Lordship.
We are not saying it is for you. You said you have no objection. Whatever amount you want to release, you release.
Your Lordship, they will release in the post
We
you are
said-
absorbed, Your Lordship.
We said department will release the pay benefits, which according to the department, the petitioner is entitled to.
Yes,
Release
yes,
that amount.
yes,
In the meantime,
yes,
further claims will decide.
yes.
And then you file your affidavit.
Obliged, Your Lordship.
And for the respondent number 6 on behalf of Arda.
On behalf of,
Arda.
who is respondent 6?
Accountant General. Your Lordship.
Accountant General. Mr. Chakma appears for respondent 6, MS standing counsel for Karbi Anglong.
Obliged, Your Lordship.
Yes. Yes, Mr. Dubey.
Neatly, Your Lordship. This is a transfer matter, my lord. But here the petitioner is at the big end of retirement, my lord. He will retire on 30th April 2024, my lord.
Yes. Who's for the respondent?
My lord. NID department, my lord. Lordship is the order at page 40, my lord. And there is no blood persons who is coming and replacing him, my lord. Basically, it's in the existing vacancy. In terms of your lordship's order, my lord, I was allowed to join, my lord, continue, my lord, with effect from October. But the earlier. Hmm. The earlier incumbent of respondent number 4, my lord, initially did not allow me, my lord. But I had also made an allegation.
So what is your difficulty now?
But
Why are you challenging the transfer?
in the fake end of my blood, 9 months remaining blood, I have been transferred. And your lordship would see page 42.
Yes. This you will have to translate for us. We are unable to follow the language.
Lordship permit me, I read by it. I have the honor to inform you that I am working at Binakandi block as assistant account officer with effect for 27/7/2021 till today. I am offer my service in the interest of public service honestly and seriously without any discrepancy to our Panchayat and Rural Development Department policy with best of my knowledge. But the time mentally pressured me due to some of work illegally. If I have not agreed to do the illegal work as pressurized, fear me and said transfer me to Kachar, Helagadi. So I am feeling for any fearful matter. It is informed that I will retire on Swan. My lord, we have raised an apprehension because, my lord, respondent number 4, my lord, the then respondent number 4. Lord,
Yes.
Lord, in fact, tried to pressurize me to do some work, my lord, which I did not agree. And Lord, may I indicate to your lordship, my lord, he has been arrested subsequently after passing of this order, my lord. A new incumbent has come, my lord. But she also did not, my lord, allow me to join pursuant to your lordship's passing of status quo order. And there was an order also passed by the commissioner secretary, allow me to join in terms of your lordship's status quo order, but he did not allow. And my lord, though they have filed an affidavit, my lord, they have not responded to this averment of mine. And my lord will also see there is no person who is coming to take my place.
You look into it, Mr. Counsel.
Your lordship, thing is that your lordship, there is no bar that.
No, there is no bar, but
Yes.
ordinarily you don't.
And your lordship, as per
What is
the,
your parent district? Parent district?
Lord, no, the same place.
your lordship,
Nagaon, my lord. Near
Huh?
Nagaon.
your lordship, can
You are, where is the transfer order?
Page 14,
40.
my lord. I am sent to Dhubri.
Will give you liberty to consider his prayer. Oh, there is already a representation pending.
Yes, sir.
In view of the some office memorandum.
Your lordship,
Page 41.
it is your lordship, not more than 2 years. His ground is that he has not yet completed 3 years, your lordship. As
No,
per this
no, no.
memorandum, your lordship,
I
it is
ground
2
is
years.
blood. I am in the last year of service. That aspect of the matter they have not looked into.
But that is not reflected in the office memorandum. Is it reflected? Then
There is a 4th of February 2019 office memorandum, your lordship. Tenure, your lordship, tenure.
Office
First page, your
memorandum
lordship,
speaks of
tenure.
only as regard the tenure, blood. What I am on is blood that it's the last year of my service, blood. I should be placed nearby my hometown, my lord.
The official should not remain in the same place of posting for more than 2 years within same district, except in exceptional cases.
is there any policy of placing him in the home district prior to his retirement in his last year of service?
Consider, your lordship.
Heard, learned counsel for the parties. This petition is filed by the petitioner to challenge the impugned order dated 24/7/2023, whereby the petitioner was serving as an assistant accounts officer of Binakandi Development Block under Hojai Zila Porikot, was transferred and posted at Akovani Development Block under Dhubri Zila Porikot against an existing vacancy. The grievance of the petitioner is that he is due to superannuate on. When are you retiring?
30 April 2024.
3004, 2024. Stop. Considering that he is very shortly superannuating, the petitioner had represented before the authorities that he should be allowed to work in his present place of posting, in his earlier place of posting, which is also his home district. A representation to the effect was filed before the authorities concerned. That apart, it is submitted that he was actually pressurized to do some work illegally, and having refused, who had transferred you?
The commissioner, your lordship. Allegation is against
of
the
which-
video possibly.
At the instance,
Because
yes.
of which the transfer order had resulted.
Your lordship, the representation file and whether we will have to see whether the video was made party in his personal capacity or not. It is not that
The respondents have filed their affidavit and disputed the contentions raised by the petitioner.
But in paragraph 17, there is no response. There is no counter to that.
paragraph 17 for yes. The video ought to be made party in his personal capacity, your lordship. Personal aspersion is there, your lordship. Commissioner cannot answer this.
Commissioner will look into and pass an order.
That it can be, he can look into it, but so far as the aspersion part is concerned,
No,
on a particular officer.
there is no aspersion here. Is there an aspersion?
Page 41 ত আছে, এটো dispose কৰিবলৈ কৈ দিয়ক।
Where is the aspersion?
In the page 42, your lordship.
We know that. That's what we intend to do.
Dispose কৰি দিবলৈ কৈ দিয়ক।
So
Uh,
the his
considering the fact-
representation is at page
Considering
number
the
41. your
submissions
lordship.
of the counsels for the parties and upon perusal of the pleadings on record, we find that the writ petition can be disclosed at this stage by directing the respondent number one, namely the commissioner, PNRD, to look into the grievances of the petitioner and pass an appropriate order in respect of the grievances of the order, grievances of the petitioner. Stop. It is submitted that, as it is submitted that there is already a representation dated 25/5/2023 filed before the commissioner and which is stated to be pending.
May I please, your lordship?
The commissioner and secretary will dispose of the said representation by passing a speaking order. While disposing of the matter, the commissioner will also take into consideration the claims of the petitioner that he is in his final year. He is superannuating shortly, i.e. 3004/2024. And to consider his prayer that he should be brought back to his earlier place of posting. Yes.
Your lordship, the representation he has filed, so far as the transfer order is concerned, on 28/7/2023. He is now 41, your lordship.
Yes.
Case number 41.
We have indicated that.
Yes, sir.
Can the lordship this honorable court in the case of Bhava Kumar Hazarika versus State of Assam, let down in the last year of service, generally it should not be discussed.
We have indicated that.
All right.
Blood, one further prayer, my lord. He has been allowed to join blood, but he has not been paid, my lord. That consideration, blood.
Any claims of non-release or non-payment of salary, area salary will also be looked into by the commissioner. This order be the representation be disposed of within a period of 15 days from the date of receipt of a certified copy of this order.
Deeply obliged.
Disposed.
All right.
Interim orders, if any, said.
Wait, please, your lordship. Earlier, matter particular non-payment of arrears salary matter. The occasion matter instructions for me.
Yes. Instructions.
Yes, Lordship, I have received one instruction,
Hmm.
whereby it is stated that the BO was asked to submit a proposal. And the BO is seeking a week time to submit a same.
MS Kumar,
Lordship,
Learned Standing Council,
elementary education.
Elementary Education, submits that proposal from the DEO for payment of,
DO.
for release of area salary
Right.
as called for, has not yet been received, but is likely to be submitted within a short period of time. She therefore prays for further time. Mr. S. Hawk, Learned Counsel for the petitioner, does not object to the prayer made. List again. After 3 weeks,
Days, my
date
Right.
28.
Right. Upright.
Wait, please, your lordship. In this case, the petitioner with the lordship is under suspension since last 11 months because we are being any memorandum of charge.
Yes, what is the status?
My lord, they have made an inquiry. Inquiry report has been submitted by the inquiry officer to the additional deputy commissioner on 2nd of August 2023. And my lord, the authority will take the action accordingly, my lord.
What about his suspension?
Suspension, my lord, regarding suspension, my lord, I have no specific, my lord, instruction. Only I have received this inquiry report submitted by the inquiry officer. That has been submitted to the authority, my lord.
Does it reflect anything on suspension?
Suspension, my lord, it is not reflected, my lord.
The fact finding inquiry, my lord. There is no memorandum of charge upon the petition.
But they have stated, my lord, the inquiry officer, proceeding drawn against the, my lord, departmental proceeding drawn against the petitioner, so and so may be penalized by reducing him to lower time scale, so and so, so and so.
That also cannot be done by the inquiry officer.
Heard Learned Counsel for the parties, this petition is filed by the petitioner, who is aggrieved by the suspension order dated 27/3/2023, whereby the petitioner was placed under suspension by the additional deputy commissioner in charge, Biswanath. Stop. The petitioner is serving as Lot Mondal in the office of the circle officer, Biswanath, Revenue Circle under Vishwanath District. Where is the suspension order?
Suspension order also will find at case 25, madam.
Case
Case 25, madam, 27 March 2023.
Pursuant to an FIR lodged against the petitioner during his service as a Lot Mondal, he was taken into custody in connection with, what is the case number?
ACB PS case number 16 of 2023, my lord.
Where do we find it?
Well, page 25 itself.
ACB case number,
16 of
ACB
20
PS case number 16 of 2023 under section 7 within bracket small a PC Act 1988. Stop. Petitioner was subsequently released on bail by order. You are released on bail
My lord.
by order dated 24/4/2023,
24.
passed by the Court of Special Judge Assam, Guwahati. Stop. Since the petitioner was taken into custody, so you were suspended earlier.
Yes, sir.
The petitioner was suspended by the Additional Deputy Commissioner in charge, Viswanath, by order dated 27 March 2023. He was placed under suspension under Rule 6(2) of the Assam Services Discipline and Appeal Rules 1964 in connection with vigilance and anti-corruption case number ACB PS case number so and so. Stop. Since his date of suspension, the petitioner had remained in suspension. Stop. It is submitted by the learned counsel for the petitioner that pursuant to the suspension order, no review as required in the law has been, no review of his suspension, no review for further continuance of suspension has been undertaken by the authorities concerned. Stop. A representation dated 25/10/2023 was also filed before the authorities concerned, requesting him for reinstatement. However, the same has not been redressed as on date. Having no alternative, petitioner has approached this court, filing the instant writ petition. Stop. Para. Notices have been issued in the matter. On 19/12/2023, respondents were permitted to file their affidavit. Stop. However, no affidavit has been filed. The learned government advocate was permitted opportunity to complete his instructions. However, the instructions which have been placed before the court reveals that a disciplinary inquiry has been conducted against the petitioner. And what is the recommendation of the inquiry?
Recommendation, my lord, to penalize to reduce his time scale like that.
And the inquiry officer recommended for reduction.
Penalized by reducing him a lower time scale.
Reducing him to lower time scale.
Reduction to a lower service grade or post or lower time.
And for reduction to a lower service grade or post. Stop. It is submitted that the inquiry report is presently under consideration before the disciplinary authority. They have not passed any order.
Not passed any order, my lord.
You have been served with a copy.
No.
I think we would show cause notice they would have.
Fact finding inquiry was conducted. No, no charge has been served.
It is not said like that fact finding.
Mr. Ayed Soikia, however, disputes the submissions made by the learned government advocate to the effect that there is no inquiry conducted against the petitioner. It was only a fact-finding authority and therefore there is no question of imposition of any penalty. But the fact remains that no review of the suspension as required in law has been conducted. Stop this position. The fact that no review of the suspension has been conducted is not disputed, has not been countered by the learned government advocate.
As I have not received any instruction.
Is there any instruction to be
No,
received?
no.
Stop. Having heard learned counsels for the parties, This court is of the view that time and again, this court has passed several orders directing the respondent authorities interfering with suspension orders where there is a failure on the part of the competent authority to review the continuance of suspension as mandated by law laid down by the apex court in Ajay Kumar Chaudhary reported in so and so. Stop. His judgment has been followed by at least 3 division bench judgments of this court reported in so and so, so and so, so and so. Stop. As well as several other coordinate benches judgment. Stop. That apart. Office memorandum by office memorandum number so and so dated so and so, the government suspended the government in the competent in the appropriate level has having taken note of the principle called out in Ajay Kumar Chaudhary has brought out this office memorandum and directed all senior-most secretaries of all departments to ensure that memorandum of charges and charge sheet are served before the on the delinquent officer before the expiry of 3 months from the period from the date of the order of suspension. By the said memorandum, it was directed to ensure that currency of the suspension order should not extend beyond 3 months. And if within the period of 3 months, the memorandum of charge or charge sheet has not been submitted, they are also directed to ensure currency of suspension should not extend beyond 3 months. If within the said period, the memorandum of charge or charge sheet is not served on the delinquent officer. Stop. It is further stated in the OM that if the memorandum of charges is served within 3 months, a reasoned order must be passed for extension of the suspension wherever necessary. It is also stated in the OM that pursuant to the OM, senior-most secretaries shall undertake a review within 6 months as regards the desirability to further continue the suspension order. And senior-most secretaries will be held responsible if cases of suspension in their respective departments are not dealt with and reviewed accordingly. This notification is extracted below for convenience. Para. In Ajay Kumar Chaudhary, the following guidelines were laid down. These were accepted and applied by division benches of this court in writ appeal number so and so, so and so. And in Rafiquddin Supra, division bench held that the principles called out in Ajay Kumar Chaudhary will be applicable in cases of suspension under Rule 6.2 as well of the Rule 6.2 of the Assam Services Discipline and Appeal Rules 1969. Same view was adopted in Ajit Sonwal and the judgment of Regan Halway. Stop. In view of such authoritative finding by the apex court followed by 3 division benches ordered this court as well as the office memorandum issued by the Department of Personal Government of Assam, there is no reason for the authority not to consider the cases of suspension or revocation there or review thereof in terms of the OM number so and so dated so and so. Under such circumstances, this court has to unequivocally come to a conclusion that the continuance of suspension of the petitioner with effect from the date of his suspension, namely date of suspension,
Suspension is 27/3/2023, madam.
page,
Page 25, madam.
(27/3/2023), having not been reviewed, and which position the learned government advocate has not disputed on the basis of instructions received. Omar, the impugned order dated so and so is required to be set aside and interfered with. Stopped. The impugned order dated so and so is therefore interfered with and set aside. Petitioner will be reinstated in service forthwith. His subsistence allowance during the period of suspension, as per the provision of law, if not released, is directed to be released forthwith. And however, this order shall not bar any proceedings that is contemplated to be held against the department or already instituted against the department. Copy of this order be marked to the office of the senior government advocate for onward communication. This petition accordingly allowed, disposed of. Should we impose a cost for not filing affidavit?
Not, my lord, because the court asks us to obtain instruction, that's why we are taking instruction. We have received instruction, my lord.
In view of the findings of this court, as well as the office memorandum dated so and so, the court expresses its displeasure in respect of in the manner in which the department neglected to comply with its own office memorandum. Such conduct is deprecated. However, on the given facts and circumstances, the court refrains from imposing cost of litigation to the respondents. Writ petition disposed of.
Obliged.
Any pending interim orders are merged. Pending IAs disposed of. Who's appearing? Anyone else?
I'm appearing for number one.
Mr. S. Doctor for respondent one.
I'll draw your lordship's attention to page order dated 3/1/2024. The rule was issued, my lord, till date, no response.
Notice was issued.
Yes.
Notice.
Notice was issued.
Yes.
My lord. My lord, in this matter, petitioner, he had SL some 40 rupees deduction is his pension, my lord. Since, my lord, he is coming under the rejection 226, my lord, he have to place before the authority first, my lord. Without the approaching authority, my lord.
Don't raise these silly objections.
My lord.
Do you have your instructions as to what he has or he has not?
No, my lord, because, my lord, that as per the document included by the petitioner, that there is no.
Say that. You say
deduction
that
was there,
we are unable to decide on the issues raised.
my lord. Only, my lord, that letter has enclosed page number 14, my lord. Annexure 2, my lord. From this letter, my lord, it cannot be ascertained that deduction was 40 rupees deduction.
That is my assertion, my lord. Let them clarify that they did not.
What is your pay? And what is the rate at which you are entitled to? What was your last pay drawn?
Actually, my lord, I have given my paid drawn, my lord, that pension is given at 9,640.
Hmm.
That is the thing. my
You
lord.
find out that his last pay drawn, what is the pension he is entitled to?
Yes.
That will give,
Even my lord, this calculation is made by the pension department. Pension department has not detected any infirmity in there, my lord.
No, no. My
And my lord,
assertion
petitioner in
that
the petition
there is
also, my lord,
deduction.
that is not clearly stated, my lord, where that difficulty is there, my lord.
no, we are asking you to find out what is his last pay. From your department, are you not able to find out?
Last pay, my lord, that will
What
be
was the last pay drawn?
that will
And
be
what is the pension released to him?
my lord, that last pay that regarding the pay, my lord, parent department can be given of.
So what is the, why is the pension department, what instructions is the pension department
Pension
required to
department
give?
is it, my lord, during that period, my lord, he has get the excess amount of 40 rupees, my lord. Some amount, my lord, that is not, as per honorable court, my lord, that is not recovered.
What is the objection of the pension department?
No, my lord, as per the pension department, otherwise it is a clear order.
Then how can you say when you don't know what is his last pay?
So that calculation had already made by the department, my lord. On the basis of that calculation, my lord, we have released pension.
What kind of submissions are you making? We want to know what is his last pay and what is the pension that he'll get. If it is not for the pension department, why are you submitting? Let the education department submit.
My lord.
Yes. What is his last pay and what is the pension payable?
Lordship, I have to obtain
Yes,
instruction.
get your instructions.
Lordship,
Letter posted after 3 weeks, enabling the Standing Council Education to obtain required instructions as to the claims made by the petitioner regarding certain deductions made from his pension. This is an apprehension. Is it an apprehension?
So, my lord, that is on oath I am telling that I have been deducted.
We are asking you, is it an apprehension?
Because record says, my lord, apprehension.
Therefore, we want to find out what is his last pay and what is the pension he is payable. That will reveal whether it is an apprehension or not. If it is not for the pension department, let the administrative department find out.
Lordship.
Yes. After 3 weeks.
Yes, after 3 weeks.
In this matter, Lordship, we have filed our affidavit, my lord. Pension matter. Suspension matter.
In this case, my lord, the petitioner before lordship was arrested, my lord, on 1/8/2023.
Hmm.
By the impugned order at page 28, 5/9/2023, he was placed under suspension under Rule 6(2). My lord, he filed representation after his release. But the department did not consider his representation and continued the suspension order. But in this case, my lord, a slight difference is there. They have reviewed the suspension order. They have reviewed the suspension order on 19/10/2023.
Hmm.
Reviewed the suspension order. Subsequently, my lord, on 18/12/2023, they have charged with the memorandum of charge. My case is that, my lord, in terms of paragraph 21 of Ajay Chaudhary, my lord,
No review after 3 months.
my lord, they have to serve the memorandum of charge. If memorandum of charge is served, then also they have to.
Where is the order of review?
Order of review.
Review order? Review order?
Lordship, in my affidavit, Lordship, may kindly have it of my affidavit, page 43, my lord.
43.
My lord.
Page 35 also, my lord, in the writ petition, I have annexed that.
Page 43, my lord.
There is no, that is not a region order, my lord.
For fair inquiry, it is there.
Has been reviewed.
Yes,
On
my
what
lord.
grounds?
There is no ground.
For conduct of fair inquiry, my lord.
Where have you stated all that?
That is a review order itself, my lord.
So the review order says
Extended
has
for
been
another
reviewed.
3 months, for conduct of fair inquiry.
Oh, there has to be some. He's placed as what?
Senior assistant, my lord.
Senior assistant.
Lordship. And bribery is a case of bribery, my lord. Then, Lordship, the recent instruction I have received just now, my lord, his suspension order was again reviewed on 1st February, and it is extended for 3 months. And we are going to appoint an inquiry officer. Lordship may kindly give us some time. I will get the updated instruction.
What is this?
My lord, I have compiled a judgment. Only two judgments I will rely on, my lord,
Then why are you giving us the entire compilation?
as compiled
Mukul,
earlier, my lord.
Mukul.
What is it? Other comment Chaudhary, my lord, paragraph 21.
No, we are aware of paragraph 21
Here, my lord.
because now suspension review has taken place.
Yes, my lord. But
Have you challenged these review orders?
No,
I have not
Lordship.
challenged.
Then-
My lord, before review, they have to, my lord, serve me with the memorandum of charge
Under what provision?
under paragraph 21 of Other comment Chaudhary.
No, it will go as per the rules.
Rules.
But if you lost it, peruses, my lord,
All right.
Paragraph 21, page 13 of that compilation, my lord.
Yes.
Page 13, 21.
Yes.
May I read, my lord? We therefore direct that currency of a suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employee. If memorandum of charge sheet is served, a rejoin order must be passed for the extension of the suspension order. But my case is that in this case, they have extended the suspension order, but they have not charged me with the memorandum of charge within the period of 90 days. They have to first serve me with the memorandum of charge, then they can go for review. Without serving me with the memorandum of charge, they cannot go for review.
Okay, we'll keep it for admission hearing.
Lordship. In the meantime, I will get the updated instruction regarding the
The petitioner is under suspension. My lord, also we-
Well, the recent-
Is he receiving his subsistence allowance?
my lord.
Yes, he is receiving.
He is
We'll take it up.
my lord.
Take it up on 20
February, my lord.
February for
Lordship.
admission hearing.
Deeply obliged.
20 February.
Can it be on 22nd, my lord,
22nd, I have some difficult work. I'll be out of station, my lord.
or 27, my lord?
27,
On
yes.
27 February.
My lord. Deeply obliged, lord. Lordship may keep my latest instruction as part of the record.
We have kept it.
My lord.
That is already enclosed, I think.
No, lordship, this is the
subsequent.
recent, 1st February order.
Yes.
Deeply obliged, my lord.
To suspend. Yes.
In this case, my lord, we received the instruction, my lord. So for this time, we can to file affidavit, my lord. Perhaps we already received, my lord. There is interim order.
Interim order is there, man. That may be continued.
It is submitted by Mr. S.K. Medi that Learned CGC that instructions have been received. You'd like to file an affidavit. Who appears for
1 to 4, and 5.
I am for 5, my lord.
Mr. Hassan for Accountant General,
No, my lord, my it is Director General of Audit.
Director General of Audit, and Mr. Medi for
1 to 4, my lord.
what is 1 to 4?
1 to 4, my lord.
CISF.
Yes, my lord.
CISF. What is your name?
S. Upadhyay, man.
S. Upadhyay appears for the petitioner. Interim order passed earlier will continue. Till the next date fixed. List on 6th of March.
I am deeply obliged, my lord.
Highly obliged.
Yes.
Make peace, lordship. Lordship, we have filed our affidavit today, lordship.
It is submitted by MSM Kemprai that affidavit on behalf of the Karbi Anglong Department council has been filed today. Let the matter be listed for admission, as none represents the writ petitioner when the matter is called up.
I am for 1, 2, and 3, Lord.
Mr. Renupai for respondents 1, 2, and 3.
I was for the petitioner, I was on legs.
Mr. D. Gogoi appears for the writ petition.
Obliged.
Obliged.
Lordship, in this case, some instructions were supposed to be brought by me, basically relating to whether the suspension has been extended or not. They have not extended the suspension, Your Lordship.
They have not.
The issue have, charge sheet has been issued. May I give 1 or 2 dates so that Your Lordship can then, whatever order Your Lordship may be pleased to pass.
You already passed one order just a while ago.
The only thing is that here charge sheet has been issued within the due.
Huh?
Charge sheet has been issued within the, if we take the Rafet Ali case, then within 3-month time from the date of his informing us about his release from bail, has been issued, your charge sheet has been issued, he has replied to the charges, Your Lordship.
No, but
And
it has not
thereafter
been
was supposed to be
reviewed.
extended.
It has not been reviewed.
It has not, no, Your Lordship. Thereafter it was supposed to be, it is supposed to be extended, but it has not been extended, Your Lordship.
Okay, give us your dates. When were
Lordship,
you
he was-
suspended? When were you arrested?
My lord, I was arrested on my lord 24/3/2023, my lord.
23-3. He was 23-3, he was arrested by the investigating officer, and 24-3, he was produced before the learned special judge Assam.
Bail
4-5-23.
4-5.
He was allowed to go on bail by the learned special judge Assam by order dated 4-5-23. Then, Your Lordship, the earliest communication by which we can assume that he has been released on bail was 21-6-23. Technically speaking, here he does not say that he has been released on bail, but okay, still let us consider that that is the earliest communication, Your Lordship. However, on 4-8-23, he has clarified that he was on bail, he was released on bail, Your Lordship.
Now, between 4-5 and 21-6, he did not attend his office. He did not attend his work. Did you attend your work?
No, my lord.
Why? 4-5-23,
My lord,
the day you were released on bail,
my lord,
and 21-6, the day you apparently intimated.
intimated, my lord.
Did you attend work?
My lord, until unless suspension is withdrawn or I have been asked to, my lord, come to the office.
No. This is prior to suspension.
My lord,
You did not attend.
I attended, my lord.
Then when is the suspension order?
Suspension order.
Annexure 1, page 16, my lord.
Date.
24-3-23.
Huh?
He was arrested on 23-3-23.
Suspension.
Thereafter on 24-3-23, he was suspended, Your Lordship.
No, how can you be suspended? Because you said you were not intimated. You were suspended
No.
immediately.
No, that was intimated to us, Your Lordship. Then he was arrested, Your Lord. Then once
Where is the order of suspension? Let us see.
Annexure 1, Your Lordship.
Annexure 1,
Page 16, my lord, repetition.
16.
His arrest was intimated.
Then,
Lordship. Then
intimation?
for intimation about bail, Your Lordship.
Yes.
Bail, Your Lordship, technically speaking, it is Annexure 4, dated 4-8-23, but we can even assume this to be Annexure 3 also. Because 3, it is not very clear that he has not stated clearly that he has been released on bail, but since he's asking for subsistence allowance, we can say that, okay, fine, let us, that he has been, that is, in fact, that was the view taken by Honorable Justice A.D. Chaudhary in an earlier occasion, Your Lordship. That's why I'm saying this, Annexure 3, otherwise it is Annexure 4.
Then,
Your Lordship,
was notice served.
the Shoko notice served on 7-9-23. That is an Annexure 5, Your Lordship, and he has replied also and all that. Thereafter, Your Lordship, no, the suspension, as Your Lordship has pointed out in the earlier case also, then his suspension was supposed to be extended or reviewed. That has not been done. But Your Lordship, para 22 of the Ajoy Chaudhary judgment may also come into application here, Your Lordship.
That
Your lordship, thereafter, no suspension has not been reviewed from 7/9. Thereafter,
No, he filed his reply when?
on 25/9,
25/9.
he filed his reply. Annexure 6.
Then was there a review? No.
No, your lordship. My instruction says process of reviewing of the suspension and order of inquiry officer and presenting commissioner has been initiated, but no review. Process has been initiated, they are saying, so that definitely no review has been done, your lordship.
Already 6 months gone.
Okay. Disposed.
My lord,
We are interfering with your suspension.
my lord. I love it.
My lordship, my only prayer is that on the last order which your lordship has passed was very strong, your lordship, stiff order. Nothing stiffer than that, your lordship, may be pleased to pass.
We don't know. If
Otherwise-
there is a circular, you are required to follow that.
My lord.
We could have been a little more stiff
Even my lord,
by
departmental
directing
manual,
the
my lord.
department to take action against those erring officers for not following the OM. We did not say that.
Even
Please
on
convey it
manual,
to your
manual also, my lord,
officer.
it is reflected. Within 3 months, they have to review, my lord. Manual also there.
Division bench lordship, Ajit Chuna, last prayer, the honorable court has given and handle to the department to again suspend the
Fresh suspension.
last.
That's a separate.
Fresh suspension you can always do. Any number of suspension subject to prescription of the mandate of Rule 6
Rule.
and the procedure prescribed. But this will not mean to give you a handle
no.
that he is reinstated, therefore you can suspend him.
No.
No,
There must be reason, my lord.
that cannot be permitted. What is your item number?
Item number 55, your lordship.
50. Yes.
Well,
1 and 2 I am saying.
Mr. S. Dotto for 1 and 2. 1 and 2. Mr. C. S. Hazarika for
3 and 4. your lordship.
3 and 4.
Obliged.
Fifty. You are for the respondent.
Respondent, elementary education.
None appears for the petitioner. Matter passed over. Your name?
B Deca.
B.
B.
B. Deca. Ms. B. Deca appears for elementary education.
My lord, office note 1/2/2024 shows that, my lord, the track consignment record shows notice has upon respondent of 5 to 7 has been served. So, my lord, let it be posted for admission.
As per Lozima Court Order 1/2/2024, track consignment report reveals that notices in respect of respondents 5, 6, and 7 have been delivered to the addresses on 28/8/2023. And as such, service is deemed to be complete. Service is held to be complete in respect of respondents 5, 6, and 7. In that view of the matter, let the matter be listed for admission after a week.
My lord, the interim order.
Mr. M.R. Khandokar appears for the petitioner, M.S.D. Mushahari for the
Secondary
Education Department, Secondary Education.
Secondary.
Interim order,
Dated 10/8/2023 will continue until further.
it is already there.
Already there.
Then why do you require a reiteration? Already there until
Lord,
further order.
I am.
52, Your Lordship, we have not received the instructions, Your Lordship.
Now, why is it for orders? Why is it for orders?
Lordship, Lordship will fix it for admission, Lordship, because rule was issued on 29/2023, Your Lordship.
Matter be listed for admission after a
Lordship.
week.
Lordship. Obliged, Your Lordship.
May I please, Your Lordship? As per office note dated 2/2/24, Your Lordship, Laozima Court's order, Your Lordship, item, respondent number 7, item delivered, addressee. However, the address given in the cost title does not correlate with the address in which the aforesaid notice has been delivered.
You take fresh steps.
Fresh steps upon respondent
In-
number 7, under the care of respondent number 6, Your Lordship. She is presently working, there, Your Lordship. That must be.
Who is appearing for respondent 6?
Private, private.
You are also a teacher
Yes, Your Lordship.
in the same school.
Lordship, I have given consent for the mutual transfer. Then I order, then I withdrawn my consent, but respondent number 7 already joined, Your Lordship. And my salary.
Office note 2/2/2024 reveals the Laozima court order that although the track consignment report, postal track consignment report reveals that the notices have been served on respondent 7. However, the address given in the track consignment report and the address shown in the course title of the present writ petition are at variance. Stop. Petitioner has been directed to take fresh steps by registered post AD along with usual court process through the office of the learned civil judge. It has already been directed, you take steps. Accordingly, petitioner, it is directed that the petitioner shall take steps through the civil judge junior division, Kachar, on respondent number 7. Stop. Additionally, steps can also be taken through the office of the respondent number 6, under which, namely the headmaster of the school in which the respondent number 7 is presently serving. Stop. Dusty is also permitted. Matter be listed after 4 weeks. MSB Decca appears for
Elementary education.
elementary education.
Okay. Please, Your Lordship.